Welcome you all to the JIGL marathon. Your exams are just around the corner, and I have come with a pumped up, full fledged revision for the JIGL subject. You don't have to worry, through your entire exams, I will be there and I will decode every chapter, everything for you. In this marathon as well, for today's session, I will be covering multiple chapters in complete detail with all the past exam questions and in a short span. So I require attention, complete attention from all of y'all, and I will start and complete multiple chapters. Today, which chapters we will be doing, I will be telling you. My sessions are lined up in this way. One marathon I have already taken. Okay, that link also I will share in the WhatsApp and Telegram groups. You will get it in the description. And from today onwards, in the next 3 days, you will see that I will break down the entire JIGL subject for y'all, and y'all will find it super simple with proper language. All you need to do is, as and when I tell you something or I'm using some keywords, you need to make notes at the same time. Okay, that is it. And I can assure you, the chapters that I cover, nothing will come outside of it. Okay. Now, before I start, I want to thank every single student who has gone in and joined the Dream Batch, shown the trust in us. So what is the Dream Batch? A Dream Batch is an access to the paid lectures for a nominal amount of 99 rupees. I think over 656, 600, 700 students have already gone for the Dream Batch, and they are studying and doing their preparations from it. How can you join? You have to go and see the description of the video, this video. You will see that there is a Dream Batch for old syllabus and separate is for new syllabus. So whichever is your syllabus, you will go ahead and join that and enroll yourself. You will be able to watch it on the laptop as well as on the phone. Okay, sir, how do you watch it on the phone and the laptop? So obviously phone will get automatically unlocked, all the lectures will get unlocked, and you will be able to study in-depth lectures will be unlocked. Second, if you want to watch it on the laptop as well, you will go, after enrolling yourself, you have to go to this website www.web.classplus.com, put our organization code, that is IEAPQ, and you will be able to see your lectures on the laptop as well. So what are you waiting for? Go ahead, enroll yourself immediately. Now, and also one more thing is, I am thinking for giving a very good, or maybe we could say a small giveaway to all of you all, like everyone who is enrolled in the Dream Batch. A special, a coupon will be given. A coupon will be put up today in the Dream Batch video. Okay. This coupon, you can use it to enroll yourself in any of the particular courses. So I will see it will be around a 500 rupees discount coupon or a rupees 1000 rupees discount coupon. So you will be able to purchase any lecture and get 1000 rupees off also, 1500, 500 or 1000 rupees off. The details will come today in the Dream Batch as well. So go ahead, you enroll for 99 and you get benefit of a big huge discount which we never give anyone. Okay, but this time in the Dream Batch, I thought, let me just give away something more to the students, let them enjoy and start studying immediately. So once your exams are over, you would want to study for the next level, go ahead, immediately enroll and apply your discount coupon as well. It will be in your Dream Batch separately, which I will also have a separate video. Okay, now before I start with today's chapter, which all I'm going to start, I want you all to share this video with your friends. Okay, go ahead and share this video with your friends immediately. Okay, so you take the link and share it in your study groups. Okay, so this is one request from me to you. Okay, study groups, you go ahead, put this video, take the link. Okay, it will just take you 1 minute before I start with the lectures. I want to take this pause from you all, a small request to all of you all. Take the link, go into the share link, copy it and share it in all the study groups that you are there. Okay, especially this will be I have prepared a lot for this session, so you will be able to share it with your friends as well. Once I start with the lectures, I will start completing on a record, in a record manner. I will cover everything, so everything will be in, just give me 3 hours and you will see that you will get a shock of your life how many chapters have been decoded, and the entire JIGL subject is easy. Okay, so have you all shared this on your WhatsApp and Telegram groups? Please give me a confirmation. Hit the like button also, and we will start with the marathon. So I don't want to take much time. Just do this much. This is my request to all of you all. There are so many students who don't know about the classes, and all of those. So I want more students to participate. Anytime if you are a performer, you want more students, you want more audience, you want more and more people to be helped with your talent. You see on the entire, you will see there is no place where so many chapters in depth is being covered in such a beautiful manner. It takes a lot of prior preparation, which I have done for you all, and I just want it to reach to more people. So this is my request to all of you all. Please do this. Okay, so are we good to go? Can we start with the marathon? After you've given a confirmation, now I will tell you which chapters I'm starting. Thank you so much for every single student who has shared this video right now. I thank you personally, okay, for doing this favor on me. Okay, and I will make sure that this time that you're giving to me, I will make it tremendously worth it. Now, first thing is, sir, which chapters I will be doing? Okay, so now let's begin. Okay, first let's begin. Okay, so this particular marathon is for old and new syllabus students, obviously. Okay, for old and new syllabus students. So the chapters which are common I will be telling and I will be doing. Okay, now I understand in the dream batch all the lectures are there which are paid, so those are in-depth lectures. Right now you want a recap to help you pass the exam. That's my job. Okay, so that I will give you a full recap of all the chapters and you'll get a shock of your life how simple it is. Now before I start, I always tell the students, okay, I always tell the students one thing, so pay attention, that I had got an exemption in this subject. This jurisprudence, I was, I had got an exemption 60 up in my paper. So before I start, I will tell you my trick. I always told myself exemption. I will get an exemption. It's a beautiful subject. I love the subject. I'm going to top in the subject. This was my mantra and I'm going to share my first tip with you. Everyone will write exemption in the chat box. Okay, exemption in the chat box is what we are going to get in this subject. You sit for my marathon and you will be able to teach 100 people. Okay, now first thing is, this is the sub chapters which I have already covered. First, Constitution of India has already been covered. This is a 15-mark chapter, completely in depth. I have covered a few days back. That link of the video also I will share it in my group. Today, okay, I have covered this. The main is Constitution of India, around 10 to 15 marks is certain. I have beautifully covered in depth, okay, so you can go and study. Today I will be covering, okay, so today I will be covering, today's session that I will be covering is in a very rapid manner. I will cover, but rapid means what? Even if a student doesn't have knowledge, they will be able to clear, understand and write it in the manner, okay. Only thing a marathon is back to back. I don't take break, you don't take break. Okay, so this is first chapter I will cover is interpretation of statutes. It can come for around 8 to 10 marks. Interpretation of statutes. The next chapter I will be covering is law of torts. This is all today. Okay, so I'm going to cover iOS. I'm going to cover torts. Again, torts is around 8 to 10 marks. These are all chapters which can come for 8 to 10 marks. You have civil procedure code. So today also you will finish civil procedure code. You see how easy I have made it. Okay, I have got an exemption, not like a joke. I had learned every single thing. You should top in my law also, here also. So here I will be teaching you all. So pay attention. Sir, after this which chapter? These 4. Okay, so this is my target for the day. Some heavyweight chapters I will start covering. This is there. This is also 8 to 10 marks it can come. So CPC 1, 2, 3 and the fourth one is your Evidence Act. So this is today's session. I will be covering these 4 chapters in depth in a fast track manner. Now remember for tomorrow, sir, tomorrow which chapter you will be covering? Now tomorrow I can't tell you every single thing what I will be doing, but tomorrow I will cover administrative law. So tomorrow marathon, JIGL marathon, I will cover your admin law, administrative law at least, okay? This will be at least this, and then I will see which all other chapters I can cover. So tomorrow is admin law. And remember, that's it, okay? So some chapters I have already done. So are we good to go? And can we start with interpretation of statutes? Yes or no? Chalo. You are in safe hands. You don't have to worry. You are in hands of a person who has got an exemption, who has been teaching JIGL from many years. And this is my job to crack this entire chapter for you. Okay. Interpretation. It is there in old syllabus and new syllabus. And my job is to decode it in the shortest possible time. Okay. Remember, there are some rules for the marathon, for this marathon especially, because I plan to go really fast. I want you to keep your chapter open from whichever notes you have, module you have, and a pen with you, and you will note down the keywords. For example, if I'm using some words which you say, oh, he's speaking very good English, write it down. You will quote it in the exam. Clear? So let's begin with the marathon. Okay. A smile, exemption in the chat box. Everybody will write exemption. And that's how you get an exemption. Learn someone from who got multiple exemptions in this thing. I cleared in one go. This entire scared paper which you're getting. Okay. I cleared executive both groups in one go. Okay. So that's how you just put it. I will ensure that you also clear your paper. Just looking into the chat box before I start. GTG. I still want more people to write exemption. Anyone who has not written exemption, please write it there. Till now, till your exams, you just listen to whenever in the WhatsApp and Telegram groups, just be there. You will see that I have decoded the full JIGL subject and even all other subjects for you. Okay. All other subjects will be decoded, past exam questions, amendments, you don't have to worry. Everything will be done. Chalo. Let's start with a bang on smile. Great. Chaliye, let's start. Hi. So we will be starting with the interpretation of statutes. Interpretation of statutes, it comes in the exam for around 8 to 10 marks. In a short span, we will cover this entire chapter. First, let's understand the meaning of the term interpretation of statutes. First, when I ask you, what is the meaning of the term interpretation? What do you mean by the term interpretation? Interpret means to explain, translate. It means to interpret means to explain or translate into the real meaning. Okay. Now, what are we interpreting? We are interpreting laws or certain acts. Statutes is an act. So, for example, when we are reading that in your particular Companies Act, if we want to know the meaning of the term person, so I want to understand that person means what? Does it mean natural person? Does it mean artificial person? Does it mean aliens are included? So I want to understand, I want to interpret the meaning of the term person. So then you will go to the definition and you will see. So similarly, when laws are made, when any law is made or passed by the parliament, the makers, the framers of the particular act try to make it as clear as possible. However, still in future, it is possible that certain doubts arise into any words, into any sections. We have a certain interpretation issue. So where will you go? If today I have an issue with respect to Constitution of India, So I cannot go back to the framers of the constitution. So then I will say, listen, what I can do is courts, I will, a matter will go up to the courts. Court will call the lawyers, the interpreters who are there, who are, like for company law, they will call company secretaries. What is your opinion? For tax laws, they will call chartered accountants. Go through the background, see what is there and explain. Okay. So interpretation of statutes is done by courts, by courts of India. There are certain interpretation rules that a person interpreting any law has to follow, which will be the topic of the day. Now, according to Salmond, now just by throwing in some names, it gives a very authentic look. That according to Salmond, interpretation is a process by which the court ascertain the meaning of the law. So interpretation is a process by which courts ascertain the true meaning of the legislature. Clear? Okay. Sir, what do you mean by the term interpretation? Interpretation comes from the Latin word interpretari, which means to explain, to understand, to translate. Simple. And statute is a will of the legislature. So statute is an act, it is a will of the legislature, means the parliament, okay, is where the laws are legislated, where the laws are made. So the will of the legislature, the will of the people, of the parliamentarians, whoever is sitting, becomes the statute. So whenever there is a statute in which we have a doubt, we will apply IOS, interpretation of statutes. Now, tell me one thing, if there is everything clear, the act is clear, there is no confusion, is there a need for interpretation, yes or no? If a particular act is there, okay, and that act, everything is perfectly clear, is there a need for interpretation, yes or no? So the answer is no. Interpretation of statutes will only arise when any particular section, provision of the act is ambiguous, is not clear, or it is uncertain. Sir, ambiguous means what? Ambiguous means two meanings, double meaning. One section I'm reading, like for example, I give you best example is person. Person, when we read, is an ambiguous word, because person could mean natural person also, and person could mean artificial person also, or it could mean both. So there is a confusion, it could have multiple meanings. So that time we will apply the rule of law, we'll apply certain rules. So the very first rule is called as your primary rule. So now we are going to see the rules of interpretation. So when a particular interpreter is called, okay, so when we are called into courts and we have told, just go through this, what do you think, what is your understanding? So that time we have to apply some rules in order. They have given which order you have to go for the rules. The very first rule that we will apply. So for example, when I'm reading a particular act and I realize that there is a doubt, I will say, first rule I will apply is called as the primary rule, or the grammatical rule, also called as literal construction. So in the exam they can write, these are exam questions, okay. Now I'm coming to, one is the introduction. Now you will write the main law that can be asked. They can ask, what is the literal construction give? What is primary rule under IOS? What is grammatical rule under IOS? So then it is very simple. Pay attention. They say that normally what we do, we apply the dictionary meaning, we apply the popular meaning, we apply the well-known meaning. Okay. So the primary rule says the words, phrases and sentences, the words, the phrase, the sentences in a statute should be understood in the ordinary, popular and natural or grammatical meaning. Means what? Any word, any section, any phrase that is there in the act, we will apply the normal dictionary meaning and we will see and we will apply it. However, if that meaning is leading to absurdity, some kind of issue or some double meaning, then we will not apply. So if we are fitting a word and it fits exactly, then it is making sense also, then we will apply the dictionary rule, primary rule, and move ahead. So what is the first rule? Called as literal rule. Literal rule means what is being given, see the dictionary meaning and apply it, finish. But don't apply it if it is leading to absurdity, it is leading to stupidity, doesn't make sense, then don't apply it. Okay. Now in the literal rule, the words of the enactment first give it the ordinary, natural or popular meaning. So when we see, again, I'll give you a very stupid reason examples also, and then I will give you legal examples also. Let's say it is written that all baby food is exempt from tax. If a particular notice comes in this that baby food is exempt from tax. Okay. Now the question came up, what is the meaning of the term baby? So imagine I know baby, someone will say, listen, I call my baby is here. Okay, we went on a date with my baby. So then law says we are not talking about this baby that you randomly call a person of baby. We are not talking baby. Then we will go as per the dictionary meaning, as per the popular common sense meaning, that a person might be of less than 7 years. They are called as baby, and then it is there exempt. Okay. So that will be applied first. Interpretation should not be given such that it makes anything else redundant, ineffective. Okay. And one basic rule is there which is applied everywhere. Sir, what? So basic rule is that every single word is important and interpretation should be given such that you have to interpret it in a way that the object of the act can be fulfilled. Clear? So what is the final conclusion? What we will write? So the words of the statutes must be given the primary natural meaning at the first instance, unless it leads to absurdity. Absurdity, you will use the word which means stupidity. Clear? Is the literal rule clear? Yes or no? Literal rule is why called as dictionary rule as well. Okay. So first rule of interpretation iOS done. Simple. Okay. Next. Okay. Next we go here. Next rule is your rule which comes from literal rule only. That normally we apply the dictionary meaning. But if the dictionary meaning is not giving a correct approach, it is not giving a rational interpretation, it is leading to absurdity. Okay. In that case, we will depart from the dictionary meaning. We will go away from the dictionary meaning and apply a reasonable meaning to the particular sentence. Clear? So easy. So this, when we apply a reasonable meaning by departing from the dictionary meaning and apply it, it is called a rule of reasonable construction. Okay, so how do we name it? Normally a statute is construed, understood in their ordinary meaning, dictionary meaning. But if it doesn't serve the purpose, then the courts can depart from the dictionary meaning and give a reasonable meaning. Sometimes logically, even when you are interpreting, you go to the dictionary. But when you go to the dictionary and it is not making sense, then we don't apply the dictionary meaning. That is called as reasonable construction. Okay. So why it is called reasonable? Because courts modify the meaning of the word to give a reasonable or sensible meaning. Sir, beautifully understood. Let's move ahead. Okay. Now, should we always depart from the dictionary meaning? So we will write, no, we should not depart, or this rule shall apply when the language of the ordinary meaning, the language of the dictionary is leading to absurdity. In such case, we will depart and give it a sensible meaning. Now this line you can write anywhere, that always, this is a standard rule, okay, this is a standard rule. What? This rule has to be written no matter what is there, that interpretation should be given such that the object of the act and the subject matter of the act can be fulfilled. That means give interpretation that the object of the act can be fulfilled and the subject matter is also being correct. Okay, so this is there. Next, so we will see an example also, which was of example of these cases you can quote in the exam, okay, to give that how we have departed from the dictionary meaning and given a modified meaning. So in Lee versus Cap, it was written in the Road Traffic Act 1960. It was written that whenever a driver causes an accident, he should stop. After an accident, he should stop. Now the question came up of the meaning of the term stop. They came meaning of the term stop. So they said when we go to dictionary meaning, stop means to halt. Now for how much time it is not given. So a person after accident will halt for 10 seconds and move away. So he'll say I have complied with the Road Traffic Act. They say no. Here we will modify the meaning of the word and we will say stop here means to stop for such reasonable time where the inquiry can be taken, where the victim can be taken to the hospital, etc. Okay. Similarly, in assessing authority versus Patiala biscuit manufacturers, it was said that you should be in possession of a license of, a certificate of registration. You should be in possession of certificate of registration. So he said, okay, fine, I have taken the certificate of registration. But now they are saying, does this possession, when you see the dictionary meaning, it means actual possession, actually holding something. But does it mean that 24/7 I will have the registration certificate with me? So they say no, possession, again we will modify the meaning to say possession means he must have obtained it at some point of time and can produce it whenever we are asking him to tell in a reasonable time. So here also we shifted the meaning from actual possession to meaning to possessing means actually acquiring the registration of certificate. So when you jump a signal, okay, now I'm talking of practically. When you jump the signal and the officer tells you, the traffic officer comes and calls you that show me your license. Imagine if at that time you are not carrying your license. Is it a violation of law? Do you have to physically carry your license? If you know the law, you don't have to carry the license physically. Possession means you should be able to produce it whenever they ask a photo, or maybe they will give you 15 days to produce it. That all is also permitted. If you can produce it, they will release all charges against you. Okay. So now we are done with this part also. Very, very simple. Then comes the next rule. The next rule is again a very, very, very important rule, which is a favorite examiner's favorite exam question. They must have asked it 7 to 8 times. What is rule of harmonious construction? Or I want all of you all to write it there, one word which is also called, all of you all will write it there, also called as purposeful, okay, rule of interpretation. Purposeful rule of interpretation. They had asked in the exam purposeful rule and many students couldn't know. So it is harmonious construction and purposeful rule is the same. Okay, so what does it talk about? It talks about harmony. Harmony means what? What do you mean by the term harmony? Sir, harmony means peace. Okay, harmony means peace. So what they are saying, now pay attention. When in a act, okay, in a act which they call as a statute, in a act there is a head-on clash. Head-on clash. Head-on clash means what? There is a conflict. Simple word, there is a conflict between two provisions, okay, provision 1 and provision 2, maybe section XYZ and section here, okay, of the same act, then they are saying, listen, if we are reading this, we are coming to know something. If we are reading this, it is coming something else, and we feel that this section and this section are contradictory. They are fighting with each other. So how would you interpret? So they say, interpret in a way in harmony, that effect can be given to both. Effect can be given to both. Sir, what does it mean? That whenever there is a head-on clash between two provisions of the same enactment, then interpretation should be given such that that effect can be given to both. We tell, listen, this is there, both can be applied, both are effective, you know, this operates here, this operates here, and both are. So more and more, interpretation should be there to reconcile, to make both the provisions friends. However, we cannot do it in a way that leads to absurdity, or we cannot, unnecessary, you cannot club anyone so that the object of the act is not being fulfilled. So one line which I taught you, which you will always write, that the object and subject matter of the act should be achieved. Clear? Object of the act should be achieved. Sir, give an example. Okay. So I'm giving an example. There is a conflict. There was a conflict. Now you will quote this also. This particular example which I'm telling you. For which harmonious construction. That there was a conflict in the Constitution of India only. Under Article 19 and Article 194. Article 19 said that you have freedom of speech and expression. Whatever you want, you can say. But Article 194 said that those who are in parliament privilege, they had certain restriction on speaking. If I am in the parliament, I cannot just come out and reveal the secrets. If I am sitting in a meeting, I cannot come out and reveal. So here it is saying that you cannot speak. Here it is saying you can speak. So it seems like a conflict. One is saying you can speak, one is saying you cannot speak. So they say that it looks like a conflict, head-on clash between two provisions of the same law. So then they said, they gave a harmonious interpretation and they say, listen, Article 19 is freedom of speech and expression, but they are not absolute. It is subject to certain restrictions, and Article 194 is those restrictions. Sir, beautifully covered. Let's see and finish it off. So when two provisions cannot be reconciled, then we should interpret it, understand it in a way that both can be given effect. So whenever there is a head-on clash between the same provisions, we should try to best harmonize them so that the object of the act can be fulfilled. Sir, the example that you gave, it was of Article 194 and Article 19. The case law is Sharma versus Krishna Sinha. Okay, you will write this in the exam. Sharma versus Krishna Sinha. The next example also they ask in the exam separately. What is the rule of Edinus Generis? It's a repeatedly asked exam question. What is the rule of Edinus Generis? Okay. So first, Edinus Generis means of the same kind. Okay, it means of the same kind. Now pay attention to what I'm saying. That when certain general words are coming after a special category of words, these general words will have limited meaning to that of the special category words. Sir, so difficult. So let me explain. What happens is, any other goods, what has been written in the Customs Act, okay, in the Customs Act it was written that no person, like as we go in the plane, they will write that no arms, ammunition, gunpowder or any other goods can be taken on plane. So the interpretation of the words any other goods has come. Does any other good means anything else? So they say no. Any other goods means of the same category of arms, ammunition and gunpowder. So this any other good really doesn't mean any other goods. It means any other goods connected with the special category goods, like your arms and ammunition. So which is the general word here? Etc. Whenever we see any other goods is a general word. Special category words are arms, ammunition, gunpowder. So whenever certain general words are coming after certain special category words, then these general words will have restricted meaning to these special category words. Now this is certain conditions are there. The special category should not get exhausted. This special category must be belonging to some genre, some particular classification, like arms, ammunition, gunpowder is related to certain explosives. But if I say all these previous words are not related to any particular class, then the general words will not have restricted meaning. So let's see, rule of Edinus Generis, that means of the same kind. When certain general words are etc. follows, they are coming after certain specific words, and those specific words are of a special category, then the general words such as etc., any other goods shall have restricted meaning of that of the same category. For these conditions are there has to be a specific word, there has to be a general words, the class should not get exhausted. Okay, and this rule should be applied with caution. And the case of the Customs Act case, you will write of AG versus Brown. Okay, then comes the Mischief Rule. Okay, so sorry, this is called as a Purposive Rule. Okay, Hayden's Rule. What they say, pay attention. It says that if any particular law I want to understand and there is a confusion, then they say go to the previous law. For example, if I want to understand Companies Act 2013, this is the new law. If I want to understand Companies Act 2013 and I find this any provision little confusing, so I will go back to the previous law, that is Companies Act 1956. I will go to the previous law. I will see, so first job is to go back into the previous law. They are saying go to the roots. If I want to understand any law, if I want to understand Companies Act 2013, so they say go back to the previous law. I went to the previous law. Then I will see what was the defect in that law, that why was Companies Act repealed. Then I will go into the defect, they call it as the mischief or the defect of that law. Then I will see then I'll come back to Company Act 2013. I'll see what was the remedy provided in Companies Act 2013. And I will see the object of the act. To these four things we will do. This is called why we are doing it is to suppress the mischief and advance the remedy. Clear? No, why we are doing it is to suppress the mischief and advance the remedy. Okay, so now let's see what all it is there. This is called as Mischief Rule or Hayden's Rule. It is said that, listen, what is a common law? What is a common law before the act? That was what is the previous law? What defect it did not cover? So what was the mischief or what was the shortcoming of that act that you have to repeal it? Then see what is the remedy provided in the new law, and also see the true reason of the remedy, the object of the act. So with this way, what happens if I have any particular law, I have confusion, I go to the previous law and try to then connect what is the issue and try to get the real meaning. This is called as Mischief Rule. The main purpose of Mischief Rule is to suppress the mischief and advance the remedy. In Sora Devi case, it was held, Supreme Court has expressed the view that the Hayden's Rule is applicable only when there is a ambiguous words. So why ambiguous words? Because in case of direct, clear meaning, rules of interpretation are never applied. Rules of interpretation are applied only when there is a confusion or a doubt. Now we see some other rules also which have been given. So Expressio Unius ex exclusia altris. So this also comes in the exam. From here you will understand the word expressio exclusia. That means a express mentioning of one thing. If I expressly mention one thing, that means I am excluding another category. For example, I am saying that there are all boys in this room. So when I made an express mentioning of one thing, I am clearly excluding girls. That means girls are not there. So an example of this in law is when I say that the fundamental rights or Article 19 is available to citizens only, or Article 14 is available to citizens only. Okay, so when we say like this, that means that foreigners cannot apply. So what is this rule say? That express mentioning of one thing means the exclusion of the other. If one or more things is mentioned expressly, clearly, then it leads to certain other things obviously being not included. Okay. For example, in Bennett Coleman versus Union of India, Article 19 says it is available only to citizens. That means non-citizens cannot claim this right. So the express mentioning of one thing means the exclusion of others. Then comes Contemporanea Expositio Est Optima Fossima in Legi. So from here we just have to remember the word contemporary. Contemporary means what? You have to go back into time to become a contemporary when the law was being made by the framers, and then see what is go in the shoes of the makers. So just what line we'll write? In this interpretation rule, we try to go into the shoes of the makers. We try to see when they were passing the law, what was the conditions then, what happened around, etc. So this maxim means that the best way to give the meaning to a document is to read it as it would have been read when it was made. So whenever we want to interpret it, we have to read it as per how the framers would have read it when the law was being passed. Statutes should be interpreted as though they have been at the date when they were passed. So we are trying to understand, going into the makers, their mind, how they would have read the particular provision. So this rule is called as contemporary. Then comes nostrius socius means what? From the preceding and succeeding words, I try to give a meaning to this word. For example, there is a word, I don't understand this word, but there are some words which are coming before and there are some words that are coming after. So they call it as associates. Nostrius socius means associate. From its previous and afterwards, whatever comes, we try to understand the meaning. So nostrius socius means a particular word can be known by its friends, by its associates. We can interpret the meaning of the words by the associating words. Okay. So this also we do that whenever we don't know the word, we try to go into the full sentence and we see what is coming before, what is coming behind. So the meaning of the word, the interpretation can be derived from the preceding words and the succeeding words. So we are trying to find a connection with the companion words. Very easy, very important. Okay. Now comes to one thing which is a repeated exam question: strict and literal or beneficial construction. What is the this they ask? Strict or liberal construction. So let's understand what it means. Firstly, that certain laws have strict interpretation. That means we do not allow transgressing into the extra words, etc. What is written, we will read it word by word. Anything extra we cannot put. So strict interpretations are always for penal statutes or which put a burden like tax. Strict interpretation is always for two things. One is for penal statutes, so which put a crime, which put a penalty. So we will see that if you have done the crime exactly as per law, then only you can be punished. And second is the tax laws. So tax laws also we will go exactly word by word into the law and see whether tax is leviable or not. So we cannot try to extend and say that listen, you pay the tax, listen, you go into jail. That extra we cannot ask. It will be strictly interpreted as per law. There is no loosening of the meaning. So how do you write it? First you will write that it is for penal and taxation statutes. It is a well settled rule that construction of penal statutes, okay, is done in a strict manner so that we try to avoid the penalty for the person, because we will try to give him innocence, the benefit of doubt. Unless he is exactly fitting it, we will not try to put him in jail. Okay, so because if he is found guilty, he goes in jail, he gets a punishment. So we try to keep it that, listen, is he exactly done it, has he exactly done the crime, then only do it. Similarly, tax which poses a burden should also be very strictly in the ambit of the tax law, otherwise tax cannot be imposed. So let me ask you a counter question. I applied the law very word by word and it came out that the person is not liable to pay tax. So can tax be levied? So answer is, listen, as per word by word, if it is not coming, then tax cannot be levied. However, the second is called, the second now we will be doing, now this was strict interpretation. But anything which has benefit, we can loosen the meaning of the words and try to extend and the provisions of the words, meanings, etc., and give a benefit. So beneficial statutes are given, so liberal construction, that is a easy going, we try to be liberal, not very strict with respect to the meaning of the words. We will say, listen, give them benefit. Okay, so this will come in mostly in case of labor law cases, labor laws. What we do, we try to extend, so even if he's not strictly coming into the definition, we will try to give him benefit. So I'll give you an example also. Beneficial statute is a statute which confer benefits. If we make a liberal reading, then they get the benefit. So we try to be as liberal as possible, as easy going as possible. So for example, if the person, I'll give you an example also. Now a person got an employment injury. In employment, he got an injury. Now the injury, we are wondering whether it is a partial injury or it is a complete injury. For this we are giving 1,50,000 compensation in law, and here we are only giving them 75,000 compensation. So when we say, listen, if you have to interpret it, we will try to interpret it in a way that he gets more compensation. So we will try to say, okay, fine, if his thumb is cut, his hand is not cut, his thumb is cut, but still we will treat it as a complete injury and we'll give him 1,50,000 rupees. Okay. So in your alembic chemicals, versus a workman, it was said that we had to give him paid leaves for certain weeks. So in week they started saying that, listen, we will take only 5 days or 7 days. So you tell me, a week, if I have to give paid leaves, paid week, okay, so should I count 7 days in a week or should I count 5 days? So the employer will say, listen, this working is only 5 days, as it is on Sunday they don't have to come, why I should pay for that day? So law said, no, whenever we come, we will try to extend it more and more to give them benefit. Okay, so whenever it comes to minimum wage also, we try to give them more wages wherever interpretation can be done. So always a liberal statute or beneficial statute will be construed, will be interpreted, will be understood in favor of the workman or worker. Then comes aids or internal and external aids. Now means what? Let's understand. So now we are done with the rules of interpretation. Only these many rules are there. Only these many questions can be asked. Now when the act is being passed, when an act is there, any particular act is there, it will have, in the act only there are certain aids to interpretation. Aids means helps to understand interpretation. Okay. So in Companies Act, section 1 will be written as the title. So in any act you see, this is called as internal aids. What are internal aids? Anything help to any help made by the framers of the law within the act itself, like your definitions, your preamble, your schedules, your sections, your anything with examples in the act, anything which is within the act, which is helping to understand the law, it is called as internal aid. External aids could be a dictionary, which is outside the act. Parliamentary discussions, foreign statutes, those are external. So let's start with internal aids. The first one is the title, that is your section 1. It tells this act is made to consolidate the law relating to company law, is to strengthen, whatever. In section 1 they will give you. The short title is the name of the act. Long title, it will also tell you for what it is made, the purpose of the act. Normally they write the word in any act you seek to consolidate and amend the law relating to whatever it is. Preamble. Now what is a preamble? A preamble is given at the start. It is a key into the framers. Okay, if the act is ambiguous, we can refer to the preamble for interpretation. Then comes headings and chapters. Now in the act also, when we see a Companies Act, now you are a Masters of Companies Act, you will see there are chapters for incorporation, there is a chapter for directors, there is a chapter for winding up. So when I want to read something, I just go to that chapter. So act is divided into headings, notes, etc. That all will be done. So that's also an aid to interpretation. Then comes marginal notes. Certain notes are given in the margins. Sometimes they give you references of the amendment. They give you the form number name. They give you, certain when was it amended. They give you some definition there. The person here means so and so. So marginal notes are side notes. They are inserted at the side. They are not given much weightage, but in case of ambiguity, we can refer them. Then comes to interpretation statutes. Interpretation statutes means your definition section. So every single thing you see, mostly definitions are already given. If I want to know what is meaning of free reserve, there is a separate section. If I want to know the meaning of the term, what is the meaning of term of year, financial year. So where I will go to the section 2. That is always there and mostly given in section 2 of the acts. Then comes to proviso. Now proviso is important, let's understand. A proviso has two purposes. A proviso of an act has two purposes. One, it can be made, a proviso can be used to carve an exception or to make a qualification. So you will write that a proviso is made either to carve an exception or to add a qualification. So you will read any act you read, it will be written provided that so and so, provided further so and so. So sometimes when they want to say, I'll give you an example. Like, they say that in how many times we need to have a board meeting in a year? In a year, how many board meetings are required? I want you all to tell me quickly. Okay. How many times we have in the board meeting? So in the board meeting will be there 4 times in a year. Provided, now exception will be given. Provided for one person company and small company, it will not be 4 times, it will be twice in a year. So what did it do? It carved an exception. Clear? So they give an exception that, listen, for this is the general rule, provided this law shall not apply to XYZ. That is an exception. Now second, I will tell you the purpose of a proviso which can be used as a qualification. Okay. Now qualification means, I will say that you can practice as a company secretary. So you'll be really, really happy. Yes, I can, provided you have got a certificate of practice from ICSI. Provided your name has been entered in the membership. So provido is like a condition that you can do it provided you are you have cleared your exams. If I want to do operation, then it's a provided you have done this. So your provided is like a condition. Another example of proviso as a qualification or as a condition. For example, I'm saying that I'm a director of a company. I can act as a director provided I have obtained a DIN, director's identification number. Perfectly done, sir. Beautifully explained. Explanation and illustrations are added. It gives you an idea. For example, in the Indian Penal Code only, they give you an illustration. That when they say murder, then they will say murder means stabbing someone, killing someone, choking someone. If they say the word, housebreaking, then they say housebreaking means making a new lock, breaking the door, windows, and entering into this amounts to housebreaking. So they give you the offense, and below they give you an illustration of what that offense can be. Then schedules are there. Schedules comes at the end of an act. Once the act is over, then there has been schedule. Now schedule could be something which is very basic. They want to write it in general. After the act, they will mention in the schedule. For example, they will tell that the fees will be provided as given in the schedule. They will say this labor law applies to any industry specified in the schedule. So schedule is placed at the end. It is to provide anything in depth, in greater detail, which they don't want to put in the act at the moment. Then external aids are parliamentary history. Right when the law was being passed, there must be so many debates. I go into those debates to understand the law. Certain dedicated committees are made. For your Companies Act 2013, we had J.J. Irani committee. Okay, so we will go to those committees, findings, etc. Now come to a very, very important thing which they ask independently in the exam. Sir, what is that? Statutes in Pari Materia. So, if I want to understand a law, I can refer to any other act which has the same subject matter. That is called as statutes in Pari Materia. Means statutes having the same subject matter. So, Companies Act 2013, I want to understand, I'll read Company Act 1956. If I want to understand Competition Act, I can also read MRTP Act because they're dealing with the same subject matter. Pari means same and materia means material. So we can also refer to certain statutes in Pari Materia. Dictionary we can always open, and foreign judgments also we can take. For example, we can see Rylands versus Fletcher case. Then we see a Solomon versus Solomon case. So these are what we are doing. We are referring to foreign judgments as well for understanding our Indian case. Then also in the exam they had asked, what do you mean by presumptions? Now there is a difference between presumption and assumption. What is it? Can you tell me? Difference between presumption and assumption. Okay. What does it mean? So a presumption. Okay. A presumption means I already believe something. There is a proof. There is a certain weightage in believing something. Assumption is basically, I don't know, tomorrow it will rain or it will not rain. I toss a coin, whether head will come, tails will come. It's an assumption. But if I have ordered from Swiggy, I have ordered a pizza and it is to be delivered in 20 minutes. And after 20 minutes, someone rings the bell. So will I assume that it will be the pizza delivery boy, or I will presume that it is a pizza delivery boy? You will presume, because there is some evidence. Law says that, listen, if there are some little proofs, burden, we should believe in this. Similarly, law has given you certain presumption that anything happens, we should give benefit of doubt. Prima facie, we should believe this. Let's take an example. While interpreting, as an interpreter, should I believe that law makes mistakes every time? Parliamentarians don't know the law. Every word is irrelevant. They'll say, no. Presume that the parliamentarians know the law. Presume that every word is legal. Presume that every word is necessary. Presume that everything is fairly done. Presume that the legislature doesn't make mistakes. Presume that the natural justice is normally followed. Presume that in mens rea is always required in criminal acts. Always by default believe all of this. Believe that words are not taken loosely. Okay, then so all these points we have already. Legislature knows the law, legislature knows the practice, legislature doesn't make unnecessary alterations, etc. Okay, so this is done, and that is it. We've covered the entire chapter. Okay, now only one thing I want you to note: whenever they say purpose rule of interpretation, just make the correction. You will write about Hayden's rules. Okay, you will write about Hayden's rule. Persuasive rule of interpretation, you will write the Hayden's rule. Hayden's rule. So it is purposive rule of interpretation. So we go here, we write purposive rule of interpretation. Now where was Hayden's rule? Okay, so yeah, so you will not write in harmonious construction, make a correction, not in harmonious construction. Purposive rule is in Hayden's rule. Okay, it is in Hayden's rule. This is called as purposive rule of interpretation. Clear? With this, I have completed your entire chapter of interpretation of statutes. Okay. Now we'll go to the next chapter, which is called as Law of Torts. Now again, Law of Torts is a very, very important chapter. I will finish this in a really fast manner, considering you must have already done this in CSEET also. But listen, in CSEET you might not know so much, and that was very limited. Here I will take you all through what is important from executive point of view and what comes in the exams also. Okay, so we'll just take a 2-minute breather. I'll just have water and we will restart. Till now, if you have not liked the video or you have not shared it in your WhatsApp and Telegram groups, you please go ahead and like it and also share it in your Telegram groups. We start in 2 minutes. I'm just having water and I will restart. Okay, we start within 2 minutes, 3 minutes. Okay, I just take a breather and I will start and I will complete this entire chapter in one flow. Okay, so reading your comments also, please share it in the WhatsApp Telegram groups and be with me. I'll cover this chapter also for you. Hi guys, am I audible to you all? Let's quickly start with the law of torts. And before I start, someone had asked what is marginal notes for interpretation of statutes. So remember, marginal notes are any footnotes that are there. Remember, whenever you open the Companies Act, there will be written a footnote. It will be given you the amendments. Sometimes they give you some illustrations. So this is very, in few acts you will see the marginal notes as well. Okay, so are we good to go for your particular this chapter? Okay, now just one thing is are we good to go and start with the particular law of torts? GTG in the chat box and I will quickly start and I will finish after I finish the chapter. I will stop directly after I finish the chapter. Clearly? Yeah, GTG in the chat box is waiting for you all to type. Great. Grow it. Harshvardhan, great. Okay. Chali, let's start. Hi, so we will be starting with the law of torts. Now, tort is a civil wrong. What is a civil wrong? So, just like wrongs are divided into two classes, any kind of wrong act which is there in India is divided into two things. Either it will be a criminal wrong or it will be a civil wrong. Sir, if it is a criminal wrong, we will call it a crime. It is called as a crime. Similarly, civil wrong, it's not, as you have crime, criminal wrongs are called as crimes, civil wrongs are called as torts. Clear? So this is a tort. So what do you mean by tort? Tort is nothing but a civil wrong. Done. Sir, for criminal wrongs, which act is there? It is your Indian Penal Code is there. And the procedure is contained. So it's a Indian Penal Code is there. It's a law of crimes. And the procedure is called in your CRPC, Criminal Procedure Code. Now, torts is in law of torts is there. There is no separate act which is there. Okay, it's a uncodified law. So it is just on basis of certain principles, etc., which we are going to do today, which will be there. And for this, you have a civil procedure code. Okay, so let's begin and complete this particular chapter. Firstly, tort is, you can make out, it's not a Indian thing origin. Tort is a French word which means wrong. Okay, the Latin language, it means tortum. Clear? So we've understood when there is a crime. Okay, so when there is crime, there can be imprisonment. In crime, you can have imprisonment. Here you will have to give compensation for losses caused. So if someone has done a tort, then maximum they can claim is getting a compensation, damages, etc. So examples of crime are simple: murder, extortion, okay, selling of drugs, etc. Civil wrongs are less particular, serious. So here can come property disputes. Property disputes can be a civil case. Company dispute could be a civil case. For example, someone has removed the director of the company, so it's a company disputes. All this will be a here. Okay, and we will see some other names also of torts. Now conditions for a tort to happen. So there is a wrong, so there has to be a wrongful act. So someone must have denied you something, that is a wrongful act. That's a tort. Someone has slightly pushed you, someone has abused you, so that is a wrong act. So for a tort to happen, these are called as ingredients or conditions for tort. The first thing is there has to be a wrongful act. Second, whenever there is a wrong act, it should have caused you legal damage. Legal damage could be monetary damage, could be physical damage, or it could also be mental damage. Someone came and scared me, played a prank and scared me, for which I went into 2 days hospital. So that also I will say medical expenses, tell him to pay. He gave me mental injury. So for a wrong act, there has to be a legal damage. That is, legal means in the eyes of law there has to be a damage. And for every single damage, if damage is caused, law will also have a remedy. Okay, the law will have a remedy. Remedy could be either telling the person don't do it, it's called as injunction, or company can tell him that listen, you pay him compensation. These are all remedies law can provide. Now in legal damage, there are few maxims that will come, which has also come in the exam. In legal damage, there is two maxims: damnem sine injuria and injuria sine damnem. So what is this? First is damnem sine injuria. Damnem means a damage. From the name only, damnem. So we are seeing two maxims which come in the exam, which you have to know. Okay. Damnem means a damage. Sine means without, and injuria means legal injury, not any injury, legal injury. And injuria sine damnem means what? Injuria means legal injury, sine means without, and damno means damage. Sir, what? So let's see. Okay, please write this down, what I'm telling. When we say damage means a loss. Damage means a loss. Sine always means, so damage means a loss. Sine means without. And injuria means legal injury. So only word you have to keep in mind is legal injury. So law, in the eyes of law, there has to be a injury. So let's take an example. So here someone has got a loss, but without legal injury. So in eyes of law, there is no injury. So if no legal injury, no action can be taken in court. So it is said it is not actionable in court. And if it is not actionable in court, then there is no remedy also. Because in eyes of law, there is no injury, even though there is a monetary loss. An example of this, okay, an illustration was the Gloucester Grammar School case. What happened here is a rival was set up. So from here in my institution, some people left and they started a competing business. So obviously this act of starting a competing business, my employee started a competing business. So it amounted to loss. But in eyes of law, there is no legal injury. It is without legal injury, because law says, listen, an employee can go and start any other business. If you had a separate agreement, that is different, restricting them. But if you don't have any separate restrictive clause, then they can very well go and start a business. So this was the example of damnem sine injuria. Okay, and the case you will write is of Gloucester Grammar School case. Now in the reverse example, injuria sine damnem. Now injuria sine damnem means what? Injuria means legal injury. Always. Okay. The word we are going to see is legal injury. Injuria sine damnem. Sine means without and damnem means damage. So here what is happening is there is a legal injury, but it has not caused any loss to you. So imagine in eyes of law. So you will just look at this part, that there is a legal injury. So there is legal injury. So therefore, if legal injury is there, it is actionable in court of law. It is actionable in court of law. That means you can take action, and then you will also get legal remedy. Now, example of this was Ashby versus White. In Ashby versus White, what happened? The election commissioner, did not allow Ashby to vote. and Mr. White was the officer. Ashby was from a political party. She was denied to vote. They said, no, we don't want you to allow. But it turned out that her party only won. Her party, Ashby's party only won. She filed a case. Now what the officer is saying, listen, you didn't get any injury. There was no real loss to you. Okay. It was without a loss. So there was no loss to you. But law still gave remedy to her. Why? Because her right to vote was affected. That legal right was affected. Okay. So let's see. Injuria sine damnem. Okay. So legal injury has been done, but without loss or damage. Example, Ashby versus White. Then one concept comes as mens rea. This I think everybody knows what is mens rea. Guilty mind. Now mens rea is required mandatory for criminal cases. It is not mandatory for civil cases. So in a civil case, even if I don't have mens rea, I can still be liable to pay money. For example, I have jumped the signal. I violated the signal. Now this is a wrong act of jumping the signal. So I have done it unintentionally. I didn't have mens rea. I did not see the signal only, but still I will have to pay compensation. So here normally it says that if it is guilty, if there is absence of guilty mind, there is no punishment under criminal law. However, under civil law there can be a punishment. Clear? Now we are done with the initial part. Now we will be see some kind of liabilities. Out of these liabilities, one definitely comes in the exam. So there are three liabilities that we will see. First liability. Okay, now three types of liability. Do you know which kind of liabilities are there under your law of torts? So first liability is called as your strict liability. It is called as your strict liability. Second is called as absolute liability. Absolute liability. And third liability is called as master-servant relationship, called as vicarious liability. Please write it down. From here, one will come in your exam. One comes in the exam from here. Okay. Now, first is strict liability. Sir, what do you mean by strict liability? So, strict liability says that, listen, it is called as no fault liability. It is called as no fault liability. That, listen, even if it is not my fault, I can still be made liable. I will give you a case law, everything, but write it down. Absolute liability is an Indian origin liability. So this entire absolute liability is of India. This is of UK. In India, they had one case, MC Mehta versus Union of India, where they called as no exception rule. So this liability is called as no exception rule. And vicarious liability is being liable for fault of another, for fault of another person. Sir, can you explain? Obviously, I will explain. Now pay attention. This case, there is a case law, okay? In this case, it is of Rylands versus Fletcher. Okay, the case of Rylands versus Fletcher. Here the case law is MC Mehta versus Union of India. Okay, and third, there is not a case. So what happened in strict liability? Pay attention. In strict liability, it says that any person who gets any dangerous substance or thing and that dangerous substance escapes, then such a person will be held liable who brought this dangerous substance. Common sense. I get a tiger and I keep, and the tiger, kill someone, I will be held responsible. Causes a damage, I will be held responsible. Now, strict liability had certain exceptions. strict liability and certain exception, act of God, etc. Now, what happened in Indian case law, they realized that listen, every time we give them exception, they were always going under exception and getting protected. In strict liability, there were certain exceptions where the person will not be held liable. So then, Indian case in MC Mehta versus Union of India, they said that listen, the same strict liability rule will be applied, but we will remove the exceptions. We will see all what it is there. And how can I be held liable for the fault of another? So very simple, master-servant. Master-servant liability. So the fault of the servant master will be held liable. For the fault of the agent, the principal will be held liable. For fault of one partner, the other partner can be held liable. So that is vicarious liability is also very simple. Let's see each one and finish it off. So first we are going to see strict liability. Sir, what we are going to see first? Strict liability. Case law is Rylands versus Fletcher. Now I'll tell you what happened is Rylands, he built a reservoir in front of Fletcher's house and Fletcher was sitting there. Rylands had appointed an independent contractor to set up a reservoir. Now the independent contractor came, he did not do a good job and the reservoir burst and it destroyed the property of the Fletcher. Fletcher filed a case. Rylands says, I will not be liable, catch the independent contractor. So they said, no. Rylands, you made the reservoir. You appointed the independent contractor. Now because of that, there is a loss to Fletcher. You have to pay. So Rylands was made to pay for Fletcher's property. Okay. So what does the rule say? So this is the rule. Rule says that if any person gets any dangerous substance, thing or animal and that escapes, then he shall be held liable. Finish. In Rylands case, what happened? Rylands built a reservoir, a full reservoir he built near the house of Fletcher. Rylands appointed an independent contractor. Now this independent contractor, when he was making this particular reservoir, he did not fill up some place or dirt which was there. He filled it up with wooden shafts, some wooden thing he kept, because of which water passed and it destroyed the entire property of Fletcher. So Fletcher was given compensation. Now for the facts are done. Okay, facts of the case I told you. You can read it. Now in this Rylands versus Fletcher case, also which was stated in Reed versus Leon, 4 conditions were brought in for the Rylands and for the strict liability rule to apply. 4 conditions. That 4 conditions are bent. So what they are saying, that anyone who gets a dangerous thing and it escapes or it causes damage, then they will be responsible. But 4 conditions are there. First is brought. It should have been brought by the plaintiff. I should have got it, and then the plaintiff, because of the plaintiff's action, defendant got loss. No, the defendant should have got the particular dangerous thing. So the plaintiff is the one who's asking for compensation, who's filing the case. So he must have been at loss, and now defense will be, so the defendant should have bought the dangerous substance. 1. So B is over. That dangerous substance should have escaped. E is for escaped. Okay, and D is for it should be dangerous. So a dangerous thing should have escaped. And N is for it should be non-natural use of land. Unusual activity. So if I have set up a reservoir, it is unusual. If I keep a lion as a pet, it is unusual. Okay, so that is there. So non-natural use of land. So if I use natural things which everybody is doing, then this rule will not apply. For example, everybody has a water tank. If I put a water tank and it bursts, this rule will not apply. This rule applies only when you do something unusual, non-natural, uncommon. Okay, so done. And then there are certain exceptions. These exceptions are defenses. For example, if someone has brought a dangerous substance and it escaped and caused loss, so I am liable. But I can ask for any of these exceptions and I can be safe, protected. So if I ask for any, I prove to the court that I'm falling under any of the exceptions, then in such case I will not be liable to pay compensation. So it is in favor of the defendant. First, he will say, listen, it is natural use of land. Natural use of land. Second, he will say, plaintiff only had to give in consent. I have your consent in writing. Third, I didn't do anything. It is third party who came and he did something wrong. Fourth is statutory authority. That I didn't do anything wrong. Statutory authority means under a, act of law, government has done something. For example, government has set up the reservoir and that burst. Then you cannot hold the government liable because they were doing it under a statutory authority. They didn't do out of free will. Law has told them to do. Next is act of God and own default. Plaintiff's own default. So plaintiff's own default. Okay, he only did something wrong. Act of God. Act of God means what? Act of God. That if there was immense amount of rains or there was a massive earthquake, because of which the reservoir burst. So I'll say it was act of God. Clear? Done. Now what all you will write in the exam if they ask, write a short note on strict liability. If they ask, write a short note on strict liability. I'm giving you the format of the answer. I'm giving you a format of the answer which can come for 8 marks. Okay. So first one, you will give the rule. What is the rule? That anyone who gets any dangerous substance or thing gets it at his own peril. Dangerous substance or thing gets it at his own risk. If it escapes, then you are held liable. You will write the rule. Then you will write the case law. Which is the case law? You will write. So this is the rule you will write. Then you will write the case law. Case law is Rylands versus Fletcher. So done. Full case you will explain. Then you will say this guy had to pay compensation. Then third, you will write as per that case law which I told you. Then you will write about the conditions that have to be fulfilled for this to happen, and that is bend. 4 conditions are there for it has to be done for the strict liability to apply. That is, it should be brought, it should escape, it should be dangerous, and it should be non-natural use of land. And in the fourth one, it is giving you exceptions. Exception that he had given consent, it was third party, act of God, all those exceptions that are there. Clear? You can take a screenshot. This is how you will present your answer. Now, when I do absolute liability, when I'm doing absolute liability, okay, now I'm done with strict liability. I'm done with strict liability. Now I'm teaching you absolute liability. Absolute liability was an Indian case. It was a Indian case. And that case was like how you have Rylands versus Fletcher. It was a UK. This is an Indian case. From the name only you can make up. Mahesh Chandra Mehta versus Union of India. The same rule, they said that listen, if in India we are there, anyone who's getting a dangerous substance or thing gets it at his own risk. If it escapes, it is liable. He is liable. But they say that every time we give them these exceptions, then they fall in they ask for the exception, act of God. These are nothing but defenses. So we said we will remove the exception. So here in India, the same strict liability applies, but no defense is given. No defense is given. That is called as absolute liability. Absolutely liable. No exception, no defense. Loss has happened, you have to pay. Clear? Let's see. This is called as your rule of absolute liability or absolute liability. So first thing, it is an Indian case and it applies to dangerous or inherently dangerous industries. So whichever are very dangerous, we cannot say that you have if and but. They say, listen, if you have something wrong has happened, you have to stand up for it irrespective. Okay, you have no exceptions. That is it. This rule was made in public interest. It was made in public interest, and court, while passing this, he said the courts made the following observation that when we come to dangerous industries, you remember the oleum gas leak? There was a movie also, oleum gas, on Netflix. How so many people died due to the oleum gas. So now the fertilizer company, they owe a absolute and non-delegable duty to the society, a absolute duty to the society, especially when they are dealing in hazardous and inherently dangerous substance. They are under an obligation to maintain the highest standards of safety and should be absolutely liable to give compensation to anyone who has faced harm due to their act. Whether they were negligent or they were not negligent doesn't matter. This is the rule of absolute liability. Done, sir. It was so simple. Now we come to vicarious liability. Now we are doing the concept of vicarious liability. Sir, what you are told vicarious liability? You are liable for fault of another. You are liable for the tort. Tort means fault of another. For example, principal agent, also called as quid facet per se, means what? If an act is being done through another, it is as though it is act of self. So if the agent does wrong, who will be held responsible? Principal. What is the logic? The logic is if you are doing an act to another, it is called as it is an act of self only. Done. In partnership firm, section 4 of Partnership Act, it tells you that a partner can be held liable for the fault of other partner also. Okay, can be held liable for the fault of another partner also. Same thing. Then master servant. If the servant has done, your driver has banged the car, owner will be held responsible. What is the reason? There are certain principles which say let the superior be held responsible. Same here also you will write the maxim that if you done an act to another, it is act of self, and therefore master will be held liable. Now we come to employer and independent contractor. Okay, now pay attention. Now we are doing of employer and contractor and independent contractor. What happens in that case? Pay attention. Okay. Now, normally, what is a contractor and independent contractor difference? So a contractor is working under the control of the employer, whereas an independent contractor is independent. He gets his own people. He works as per his own direction. There is no day-to-day control of the employer. So what happens? Pay attention. Okay, we will have to see whether the work is for dangerous substance. If it is for hazardous substance, then as per strict liability, the employer is liable. Because in Rylands versus Fletcher also independent contractor was done, but since it was a dangerous substance, then we made the employer liable, because you got a dangerous thing. Now whoever you get, your liability. But if it is not dangerous, then why will the employer be held liable? If it is not a dangerous thing, then we will say that listen, the independent contractor liable, because he is also independent. He is working on his own act. He is strong enough. So when it is non-dangerous, it is a independent contractor who is held liable. You can draw this particular diagram if you want. Now we will see certain torts with respect to personal safety of a person. Safety and person. Now we are seeing certain kinds of torts, civil wrongs. So first one is battery. Now battery is a use of force without lawful justification. Okay, so for example, someone comes and slaps a person. Now this had two things: use of force and without lawful justification. So it will be said that you have done a tort of battery. Finish. Okay, there is a use of force without lawful justification. Finish, done. So actually hitting someone is battery, but if you have not hit, but there is a only apprehension, anticipation, expectation that tort will be committed, that physical injury will be done. So if physical injury done, then it is battery, but if it is not done, only a apprehension is done, then it is assault. So assault is without contact. Okay, so there is a defendant is an apprehension that battery is going to be done by him. Battery means he is going to hit me. Okay, it is just the same, except here there is an apprehension that it will be done. Okay, for example, if I tell you that come here, I'll beat the hell out of you. So this is a apprehension, a fear is come. Okay, that force will be applied without lawful justification. Otherwise, the other thing is just load a gun and point it towards someone. So you did not injure him, but it is an apprehension that force will be applied. Bodily harm. If I make a statement which amounts to physical harm to a person, it is called as a tort. So just by my statement, there is a physical harm to you. For example, there is a blind man and he is walking, and I say you keep walking, and there is a open gutter. Still the blind man, you tell you go. The blind man asks, can I move ahead? Is there anything? I say, no, you move ahead. So by my statement, that person went and he fell in the gutter, got injury all over the body. So this statement you made, it called a physical harm to someone. It is a bodily harm. Next is false imprisonment. Imprisonment means what? In jail, you tell me, in jail can you go out, etc. So they say no. In false imprisonment is it affects a person's personal liberty to move around. Here what you do, you restrict a person, total restraint of a person to move. It is restraining a person to move in any direction without lawful justification. For example, you lock a person in room. Okay, this is called as false imprisonment. Now whatever, you must have done it as a prank, you must have. So there was an example where a teacher punished a student and she locked her in the classroom and she forgot. Next day morning she came and she realized that she had kept and the child was still sitting inside. Their parents filed a case of false imprisonment and asked for compensation. Finish. Here there has to be a total restraint from all the directions. So there should be no place of exit for this to apply. Then we see malicious prosecution. Now malicious means fake and prosecution means case. So this is about a fake case. Okay. So for example, if I file a fake case on someone, in the entire society, his name would have gone in, his name would be affected. He would have so much loss of time, of his mental agony, etc. I filed a fake case. It turned out that he won the case. It turned that all the allegations were untrue. Now that person on winning the case will get a power. That now he will say that this was a fake case, I won the case. Now I will file a case of malicious prosecution and ask for compensation, that listen, this case was a fake case on me and now I want compensation. So what happened when a person files a fake case against an innocent person? So this is the case of innocent person. We filed a case on him and the innocent person suffers damages, maybe loss of reputation, loss of money, etc., then the innocent person, after the case is over, after winning the case, he will file a case of tort against the person who filed a case on him. For this, what is the thing? You have to prove that there was a malicious prosecution. Malicious prosecution means what? There is a case was filed maliciously with malicious intention, with the intention to without a proper reasoning, without any reasonable cause, you filed a case on someone. That case went in favor of the innocent person. So this innocent person can file a case under torts. Simple. Then nervous shock. You call someone and say that your husband is dead, he died in an accident. And then you tell it's a prank. But that person got a nervous shock. A nervous shock is mental. So it is not a physical injury. It is a case of shock, emotional disturbance, such as fear, sorrow. So for nervous shock, you can ask for compensation as well. Then we do defamation. Defamation is very, very important. Sir, what is defamation? Defamation means to attack a person's reputation. How will you word it? How will you word defamation? So when we make a false statement, which lowers a person's reputation in the eyes of society, it is called as defamation. So there is a publication of a statement which lowers a person in society, it is called as defamation. Defamation could be in two forms, libel or slander. Slander means words. I tell that this guy is XYZ, this guy is a thief, man, this guy is untrustworthy, this guy has multiple affairs. So this is a case of slander because it is by words, it is in transient form. It is in transient form means temporary form, just by words, very difficult to prove things. And when you take a slander in court, normally you will not get any remedy. Normally, because it is very difficult to prove that I will say no, I didn't say, unless you have some witnesses, etc. But in front of, I just keep doing it behind everyone, I am talking rubbish about someone. Okay. Libel. Now what is libel? Libel is more serious, where there is a permanent form of recorded. For example, there was a video, there was a chat, there was a cartoon, there was a newspaper article. So all this is libel. Libel means what? There is a permanent form where the defamation has been recorded. Okay. Maybe I made a film of someone or movie of someone where they are showing them in low light. So they can file a case. Now under the Indian Penal Code, you can ask under civil laws also compensation, or if you want, you can go under section 499 of the Indian Penal Code also. Now in the exam they had asked that, listen, now we've understood all the torts, we've understood the different kinds of torts, but they have asked that once a tort is done, what remedies are available? What they asked, what remedies are available? So remedies are in two categories. One is from court you get the remedies, or the other one is out of court remedies you get. Again, the aggrieved person can ask for remedy, yes or no? Yes, they can ask. So now remedy can be got from court in the form of damages, compensation. Second is they can also ask for injunction, asking the person to stop doing it. The court will order the person to stop doing it. And the third one, court can ask restitution. The court can ask that restore the goods back to you. This who is giving? Court. Court is ordering injunction, court is ordering damages, court is ordering restitution, restore the property. And then comes extrajudicial. Extrajudicial means out of court I try to get my particular remedy. That is also allowed. So how that can be done? Now obviously if someone is trying to do battery, I will also give him 10 batteries. That is a self-defense. Okay, so if someone is trying to injure you. You have a right to protect yourself. Now, this protection is not coming from court. You are doing it as self-defense. Second is prevention of trespass. Trespass is also a tort. So I will not go to court. I will just catch his neck. I'll say, what nonsense. This is my property. Get out of my property. This is a prevention of trespass. Re-entry on land. If someone has entered on my land, I will re-enter on the land. Recaption. Recaption means seize the goods. If someone is sitting on my bike, okay, someone is sitting on my Activa, I'll tell him, give me my goods back. Recaption means repossession of the goods. So this is all doing it yourself. You go and take it yourself. Abet the nuisance themselves. If someone is playing loud music at 12 o'clock, one is I file a case, but who will go to court and file? I will go and I'll remove the plug and I'll tell him, I'll ring the bell and I'll tell him, stop the nuisance, abet the nuisance, terminate the nuisance. Then there is something called as distress damage feasant. It sounds very complicated, is very simple. It means, this is from a village point of view, that in village if some animal has come and eaten my crops, I will catch the animal and I will tell, I'll keep this animal till my money is not paid. So the owner of the cattle, I will tell, listen, I'm keeping this cattle with me. He has eaten all away my crops. Till you don't pay me my money, I will keep the cattle with me. Otherwise, I'll take ownership of the cattle only. You pay me my money. So it is seizing any cattle which has unlawfully caused damage on my land. Okay. So now we'll see one thing is vicarious liability of the state. Now this is also very, very important from exam point of view also. Now they ask a direct question, what is the vicarious liability of the state? Now sir, vicarious liability, you had made us do something, I forgot. Master servant. If someone has done wrong, then if the servant has done wrong, we'll catch the master. Similarly, when the state government also can be an employer. Now imagine there is a state government which has the employer, and here we have the employee. They must have employed a driver, and let's say this driver caused an accident. Who will pay for compensation? You see all these BST buses, sometimes you see on railways also there is an accident. So all this we tell not the driver to pay compensation, we tell the state government to pay compensation. So can the, now listen to my question, can the government be vicariously liable for torts of its servant? So if any government servant has done something wrong, can the government be held liable? Yes or no? Answer is yes. So government can be held liable for any wrong done by its servant. Let's see. Okay. And you have to just remember one thing, that listen, you have to see whether the act that is being done is a sovereign act. Now sovereign is supreme, only with the government of India can do, and this is a non-sovereign act which you and me can also do. So if the act is a sovereign act, for example defense, now defense of India is there, some people have, from Chinese have entered into the land of India, can I file a case? I'll say no, this is a sovereign function, defense. If imagine RBI has done something wrong in printing of currency, can I file a case? Answer is no, it's a sovereign function. Sometimes you see RBI is also handling some court related matters, court case, like all the judiciary is also a sovereign function, only they can just deliver justice. So any wrong in the sovereign act which the state is acting as a sovereign body, that time state is not liable. For this, state not liable. Okay, no compensation is required to be given. Where it is non-sovereign functions, for example the government is competing with the private sector, it is not sovereign, it's not only government does. For example, case of post, now there is government post, India Post is also there, and there is a private post, and in the India Post has lost the goods in transit, so then the government can be held liable because it is a non-sovereign. So government is liable in these cases. Clear? So postal activities or anything in airways also. Now earlier Air India was under government control, but other airlines were also functioning. So anything wrong is there, flight was delayed, etc., then the government can be held liable. Okay, so you have to see now, even when the employing a driver, yeah, small thing like appointing a driver. So government can also appoint a driver, you can also appoint a driver. Now either your driver does a loss or government driver does a loss, the government can be held liable. Clear? So you have to see whether, so you will write the answer that you have to see whether it is a case of sovereign functions or non-sovereign functions. In sovereign functions, government can claim immunity that I will not pay. But where it is a non-sovereign, it is of commercial nature that they are doing, then government can be held liable. So let's see an example. Some case laws you can write. In Ocean's team navigation versus Secretary of India, the state, they just said the state can be held liable for the negligence of its servant where they are in non-sovereign. Even the case of driver example was the state of Rajasthan versus Vidyavati, where the driver of the jeep was employed by the state of Rajasthan. So it was held that the government state was vicariously liable for the damages of the negligence of the driver. Okay. Same in Kasturi Lal versus state of UP, government was not held liable because it was sovereign powers. Damages, so again we said damages will be given. Now imagine I told you judiciary is also coming here. In the state Rudal Shah versus state of Bihar, petitioner was detained illegally for over 17 years after his acquittal. Imagine that court had ordered that you release this person, but for 14 years he was still in jail after his acquittal also, because if he is appointed for 3 years in jail, who will sit and calculate when the 3 years gets over? And now the jail authorities were negligent and this guy stayed for 14 years. Can the state government be held liable? Answer is no, they cannot be made liable. However, out of a good gesture, the court has awarded rupees 30,000 to this person because he was kept in jail illegally for a span of 14 years. So government has shown their big heart and given him 30,000 rupees. Okay, and that is it. We've completed the entire chapter along with the past exam questions. Okay, so till here is everything done? Yes or no? Okay, so is everything clear till here? Yes or no? I want in the chat box if everything is clear. Sai Darshini, thank you for your lovely comment so much. Okay. Okay, so I'm happy that all of you all are understanding. Extremely happy. Please do like the video. Now I will start with Code of Civil Procedure also. So you see that what I have done is last time also, last marathon, this marathon, I'll cover the full JIGL subject only in these 2-3 days for you. You will have nothing. Your first day only will go extremely well. Once you start with 60 plus exemption, you will definitely score, once you start on a high note. So once you get your JIGL paper, so remember this tip, start your JIGL paper really well, but because you just sit for the marathons, everything, I will cover everything for you. The one marathon I had taken before, just few days back, where I had covered constitution, and this time I'm covering other chapters. You cover it, everything will be done with the dream batch you do. You get a 60, a confirmation of 60, then your automatically your other subjects will go really well. Huh? Okay, great. Ravi Kumar, great. Also, if any of the students have not gone and enrolled for the dream batch, I have put it in the description of this chat box also. Or also it is there in the description of this video. Dream batch, go ahead and enroll. It is over 650 students already have enrolled. For 99 rupees, I give you access to the dream to the paid lecture. This is actually a gift to all the students so that I want maximum students to pass. Okay. Now we will start with code of civil procedure. So keep your modules open. I will cover the code of civil procedure along with the past exam questions. I will take a 5-minute break. Okay, 5-minute break. I need a breather. I will come back after 5 minutes. I will start and finish this chapter. Till this time, you can do me a favor, share this in all your WhatsApp groups. Let all the students know and clear the exam. Just feels good when more and more people like, share, and talk about the videos. Okay, so go ahead, do that. Even in your exam hall, please tell the students I will be having, even during the exams also, I will be having marathon. So till you don't pass the exam, you will see me. Okay, so I'll take a 5-minute break and I will return. Hi guys, am I audible to you all? So now we will start with the Code of Civil Procedure. This entire thing comes for around 8 to 10 marks in your exams. I will cover everything including the past exam questions. I want you all to open your notes and keep ready, or at least keep your modules open or any particular copy that you are there. So whatever I'll be doing, the keywords you will note it down. Same thing, nothing from outside can come. I'll be covering the entire chapter. Okay, so good to go. Just looking into the chats for your, giving me a green signal, and I will start. And then I will stop directly when I finish the chapter. Okay. First of all, thank you Sai Darshini for your really kind words. Means a lot. Okay. Okay, I especially do it for all the South India students. I used to take it in English before Hindi, but students have said, please take it in English. So I've converted completely into English. Okay, so do inform your friends as well. Okay. Harshvardhan, great, thank you again. And also you should start seriously, because one thing is you're starting now, so you need to work a lot more harder. Okay. So Akshaya, great. Sailesh, let's start. Okay. We begin with the Code of Civil Procedure. Hi, so we will be starting with the Code of Civil Procedure 1908. Sir, what is the Code of Civil Procedure? So whenever a civil matter is there, the procedure to be followed is given in your Civil Procedure Code. Okay, so a civil matter, let's say there is a property dispute. So how it will be there, what is jurisdiction, how the entire summons is issued. The entire procedure is given under your CPC 1908. Now one important exam question, they ask what is the difference between judgment, decree and order. So now as we do, I will also tell you what comes in the exam. The questions are very clear. They will ask, write a short note on or write a difference between the judgment, decree and order. Judgment means what according to you? So when I was a law student and I used to go to court, that time my senior asked me also, what do you mean by judgment? So that time I said judgment is a decision of the court, of the judge. It's called a judgment. He said no. When you read section 2 subsection 9, there is something more. Can you tell me what? It is on your screen. Read it and tell me that what more, what did I miss out when I said a judgment is a decision of the court? He said court doesn't just decide that this is right, this is wrong. They give you detailed reasons for passing the judgment. So they say that a judgment is a decision of the judge and the reasons thereof. Why? So a judgment copy will be of hundreds of pages for big matters. For everything they justify why they are giving. The reasons are given. And the reasons are based on decree or orders. So what is a decree and order? We will see. Judgment is a final copy. In the final copy, you will get the decision of the judge along with the reasons, and these reasons are based on decree and order. So judgment is easy. So what do you mean by decree? Okay, and what do you mean by the term order? So I'll explain you what do you mean by the term decree. When a dispute is there between two parties, okay, now there is a party 1 and party 2. Okay, party 2. Now party 1 puts certain allegations on party 2. So they are putting certain allegations. Now these allegations, you think only one allegation can be put. Normally allegation number 1, 2, 3, 4, 5 allegations are put. So the court will now decide that I have to first go into every single aspect and tell this transaction number 1 he's saying is something wrong, transaction number 2, transaction number 3, transaction number 4. Now 4, 5 matters are going on in one case. So then the court will then decide first matter. First they will say contention number 1. They call it as point number 1 we will discuss, and we will ask both the parties. So point number 1, allegation number 1 will be first conclusively decided. It will be decided allegation number 1 and they will pass a decree. So a decree is for one subset of a case. So it will be given for one matter, a decree. Then for second matter, they will give you another decree. For third part also, for fourth, fifth. So accordingly, for all the decrees we will see, and in the final judgment, we will base it on the decrees, right? The final judgment will be after taking everything into consideration. Here we will come to know that compensation of 30,000 has to be given. Here we come to know 20,000 has to be given. Here nil. Here there is nil. So accordingly, on basis of the decree, the final judgment will be given. So what is a decree, if I have to ask you? So a decree is a conclusive decision by the court of one aspect. Okay, so they conclusively decide the rights of the parties for one aspect. Okay, which it could be preliminary decree or final decree. For the middle of the case also preliminary decree can be given, and in the end a final decree will be given that listen, final is this. So for this matter also injunction can come, that is a preliminary decree, and after hearing all the parties, all the evidence for point number 1, then a final decree will be issued. So let's take and read what is a decree. Decree is defined under section 2 subsection 2, which says a decree is a formal expression of adjudication of the court. Sir, what do you mean by formal expression? So a decree under section 2 subsection 2 is a formal expression. That is, court has formally put it down, formally as a as a very legal process, we will put it down that this party is right. So it is a formal expression of court that conclusively determines, it is properly deciding the rights of the party with respect to all or any matter in controversy. So there were 5 matters in my example to controversy. So with regards to any matter in controversy, any matter in dispute, when the courts are conclusively deciding that aspect, it is called as decree. It may be either preliminary, temporarily they have given this order. After hearing all the parties, they will give a final decree. So what all is the essentials of a decree? So for essentials of a decree, it should be a formal expression. If court is casually saying, it is not a decree. Formal expression which conclusively determines the rights of the parties with respect to all or any of the matters in controversy, which would either be preliminary or final. Okay, done. So this is also done. The one who wins. Now for everything, now for every aspect which I gave you, for example, if we told that in this matter party 1 is right, so party 1 decree is gone in party 1's favor. So that is called as preliminary, that is called as a decree. So he is called as a decree holder. So anyone who wins the controversy, it is a decree holder. So who is a decree holder? A decree holder is a person in whose favor the decree has been passed. Sir, what do you mean by judgment dater? A judgment dater is against whom the decree has been passed. Sir, very simple. Sir, then what is order? Judgment is clear. Decree is also clear. What do you mean by the term order? Order is also formal expression of the court, which doesn't decide the rights of the parties. Then what do? Order could be, listen, your contract, it is in Arabic language. Get it translated in English. If there is a Saudi client, okay, Saudi client, Dubai client, it must be written in some other language. Chinese client, now it is written in Chinese, the contract. Court can pass an order that get the copy. Order is basically order of court which is not deciding the rights of the parties. Court is summoning someone, it is an order. Court is telling, bring the paper, bring the person, bring the witness, it is an order. Court is also telling that, listen, one of the examples of order is, the court is telling that till the time your judgment decision is not given, you keep your passport copy with the court. Passport should be kept with us. So here we are not deciding, but in order so that there is a smooth functioning of the case, the court passes some orders. So does the court decide the rights of the parties? Answer is no. It is only a direction of the court to a direction with respect to a procedure. So it's a procedural aspect. Another example of a decree is basically, listen, till the goods, perishable goods are in dispute, whose goods it is. Now case can go on for 1 year, but perishable goods, then court will order till the final decision is given, please sell off the goods. Now it's an order to sell off the goods, but they're not telling who's right, who's wrong. That is to be decided. But till that time, for the smooth procedural aspect, sell off the perishable goods. So again, what is an order? Order is a formal expression which is not a decree. It does not dispose of the any aspect of the case. It is a mere direction to the procedure. Sir, done. Sir, difference between decree and order, done. Decree conclusively determines the rights of the parties. Order does not determine the rights of the parties. Decree is appealable, but order is just a direction, so it is normally not appealable. Decree can be order preliminary or final. Order can never be preliminary. Order will always be do it right now. It is always final. Now, one of the examples of orders which are given, example of order is interlocutory order. Sir, what is interlocutory order? I just explained that sale of perishable goods till the final decision is given, when court has to sell, it is called as interlocutory order. Interim orders like power to sell off the goods. Now coming to cause of action. Now let's say if someone has entered in your property. Okay, I'm talking about trespass. You open the door and suddenly you see someone is having popcorn and having Pepsi and watching TV on your couch and you don't know who this guy is. So don't you think you have to go to court? You have to take steps? Yes, you will take. So what was the court will ask, what is your problem? So you'll say there is a cause of action. The trespass is the cause of action. Cause of action means reasons for filing the case. Someone did defamation, then that is the cause of action. If someone has banged your car, then that is the cause of action. So law says that, listen, whenever the cause of action arose, within the reasonable time you have to approach the court. So cause of action has two things. When the cause of action is there, there is one thing you will have to prove that, listen, I had a right and that right has been violated. That is why I am coming to court. And second, also you have to tell the court that, listen, I'm not coming just to complain. I want remedy, with the hope of getting remedy. Clear? So cause of action means the reasons for filing the case. Cause of action means why are you filing the case? Simple. Now jurisdiction. Now jurisdiction means the power of, I'll tell you first technically, then we will see whether you understand it or not. So jurisdiction in technical words means the power of a court to administer justice. The power of a court or an authority to administer justice. For example, the properties of Mumbai, you filed a case in Kerala. So can the Kerala court pass an order? So court will say, listen, I cannot administer justice because the subject matter is not in my area. So that area is called as jurisdiction. Okay. So jurisdiction means the right of a party, the right of an authority to pass a judgment. So jurisdiction could be of different kinds. One jurisdiction is with respect to subject matter. For example, when I talk of labor matters, only labor court can take up the matter. So this is a jurisdiction over subject matter. Subject matter means what is the title, what is the issue type. Motor vehicles go in separate case. Family matters goes in separate court. Income tax goes in different courts. Your respect to your company law related matters goes in NCLT. So this is with the what is the subject matter of the case. Accordingly, you will go to that specific court. So if I say it is with respect to drugs, so there is a separate institution for drugs. You will go there, etc. So this was about with respect to the type of case. Consumer court will go, consumer matters will go there. Then comes territorial jurisdiction. Sir, what do you mean by territorial? With the area. So you have, where do you live? Which is your area? That police station will apply. For example, I live in Mumbai. So the nearest police station, they will have territorial jurisdiction. So any matter goes on, we will go to the nearest police station. That is a territorial limit. So that authority will say, I have power to administer justice in this much area. That is territorial jurisdiction. Then comes over person. Now, presidents, prime minister, foreign ambassadors, foreign nationals, they are not subjected normally to the lower level courts. They are given to the high courts. So even certain courts have power over certain persons. Okay. So a small causes court can never take a matter with respect to a prime minister. Okay, over persons. Now the fourth one is pecuniary. Pecuniary means monetary jurisdiction. So if you see your consumer courts which is there, up till a certain limit you go to that particular district level, then you go to state level, and beyond that you go to your national level. So pecuniary means with respect to the monetary limit. So depending on the monetary value you will go to court. So which are the four jurisdiction types? So first jurisdiction is with respect to subject matter, then second is with respect to the territorial area, then comes with respect to the pecuniary, that is monetary aspect, and then is over person. So very simple. Then jurisdiction can also be classified into original, appellate, and jurisdiction. Sir, what does it mean? So jurisdiction means the power of the authority, can also be original and can also be appellate, and some authorities have both. Sir, can you give example? Obviously I can give example. So the very first thing is High Court and Supreme Court. High Court and Supreme Court, they have original jurisdiction, means matter will be first tried here. First filing of case is done here. So in High Court, some matters are there which can be directly filed in High Court, and some matters have to go down, and from down it will go in appeal here. So they have both original as well as appellate jurisdiction. Some authorities can only take appeals. Okay. For example, your ITAT, Income Tax Appellate Tribunal. So when I say Income Tax Appellate Tribunal, the first case cannot be filed in ITAT case. It is appellate tribunal. So only appeals can go here. So they have only appellate jurisdiction. Some have only original jurisdiction, like they will have only first level case can be handled. And some have both. Let's take an example. If I'm talking of consumer court, district court, okay, district consumer court. Now district doesn't have appellate jurisdiction. They can only take the matter first, and from it will go into appeal into state and national. Okay. So High Court, Supreme Court have both. Okay. So original means first the suit is filed in that particular place. Appellate means it can take in appeals, and both means it can take both. Now we come to the most important part of the chapter, which is about stay of suit and res judicata, res sub judice and res judicata. In the exam, they ask you write res sub judice or they ask res judicata. So the sections are pretty much simple. Pay attention. Res sub judice is in section 10. Okay. Res judicata is in section number 11. Clear? Section 11. Res sub judice and res judicata. Sir, res sub judice means what? It means stay of suit. What does it mean? It means stay of suit. So what does it mean? Pay attention. If a matter is ongoing in one case, in one court, can we file the same case in another court? Matter is ongoing in see, simple point is here court A has taken a matter is pending. In court A, matter is pending. Can we file the case in court B also? So they'll say, what nonsense, why do you want to file multiple cases of the same matter in different courts? It will lead to burdening of court, it will lead to multiplicity of suits, and it will lead to conflict of judgments also. If tomorrow you filed in B, B gives another judgment, A gives another judgment. So they say B should not proceed with the matter, B should stay the case. They will say, listen, I cannot take up the matter because matter is already pending in another court. That is res sub judice, which is such a simple little rule. Res sub judice. So what does it say? The court shall not proceed with the trial of any suit. The court shall not proceed with any case in which, now they are telling the second court, okay, they are telling the second court. So the court shall not proceed with any trial if the same matter is directly and substantially in issue, means the same matter is ongoing in a previously instituted suit between the same parties litigating under the same title, that there is also plaintiff, he is also defendant, cases or subject matter is also same, in another court in India, then the second court should not take up the proceed with the trial. So they said in India. So that means if it is a foreign court pending, so in India we can take up the matter. So if there is one case ongoing in USA, the same subject matter can be filed in India. That is allowed. So in India, two cases cannot be filed. Okay. So section 10 prevents concurrent courts of same concurrent jurisdiction simultaneously trying the suit. So court A also has the same jurisdiction, court B also can take up the matter. So we prevent two courts of same jurisdiction to take up the matter simultaneously. So what we will write in the exam? So you will write the conditions. So first of all, there has to be two cases, case 1, case 2. The matter in case 1 is same as substantially same as in case 2. It is between the same parties litigating under the same title. Same parties mean A and B, and A is a plaintiff, B is the defendant, and again here also it is coming under the same head only. A and B, A is a plaintiff, here it is a defendant. Means it's a exactly same suit. So then they tell the second case court that do not take up the matter, but only thing is it should be pending in any case, any court in India. Then only the rule will apply. Section 10. Now we come to section number 11. Section 11 is very simple. No person shall be punished twice for the same offence. So this we have already done in your constitution. Article 20 sub-regulation 2, sub-article 2, which says that no person shall be vexed twice. Res judicata is telling the same thing. That if one person, pay attention, has one case was ongoing, court ended, the case ended, party was punished. Now a person wants to again file a case with respect to that same matter against the same party. So court will say, you're stupid, what same matter you want to file against the same person who has already been punished. So we cannot punish him again. So section 11 is saying, deals with doctrine of res judicata, which is a bar or restraint. It is barring someone, stopping someone from repeatedly filing litigation on the same issue. It says that no person shall be vexed twice. Okay, so what are the conditions for this? First of all, the matter is the same between the same parties litigating under the same title. The first case has been heard and finally decided. This is important. What is it? The issue has been, in that earlier case, it has been heard and decided. So in that case, the subsequent suit shall not be taken up. Okay. Why? Because obviously person has been punished. So it's a very logical thing. Res judicata. Now there is something which is called as constructive res judicata. Now pay attention to this. Now imagine matter has already been decided, punished. So then the person is not allowed to file a case, because One person will be punished once only na, for that same act. So what I say, listen, I could have put 3 more points I could have said which I forgot to put in that point. Now imagine what is happening is a party is coming. Party is saying, listen, this transaction was there. It caused me loss and I had filed a case and I won the case. Person was put under penalty. Now again I want to file a case on that same thing. Court says you will not allow. But I say, listen, I could have said some few points which I did not say that time. That is why I want to file a new case to add those points. So court will say, listen, this is a constructive res judicata, that matters which could have been taken, if not taken, are also deemed to be resolved. So matters which you could have been taken but you did not take, so it is your negligence, we will end the matter because we want to put an end to litigation. One. Second is the party did not raise the question that time. Now for the same matter we will not allow them to raise it here. So it is not about absolute justice. We are not thinking about absolute justice. We are thinking of public convenience. We are looking of convenience. That party will be like saying, you know, I have already endured a 10-year case. Now again same matter is being raised just because that guy forgot to put some 2 points. So it is on grounds of public policy it has been made, and matters which could have been taken, which were not taken, are also deemed to be decided. So let's read. Constructive res judicata means matters which could have been taken on grounds as a defense or attack, okay, in an earlier suit, are also deemed to be decided because court wants to put an end to litigation. Party should not be unnecessarily harassed, okay, and the court of time will also be wasted, and it is a rule of convenience, not a rule of absolute justice. Done. Sir, what is difference between section 10 and 11? So 10 is sub judice. It's a stay of suit where both the matters are pending. Res sub judicata, the matter is decided. Finish. Okay. Now, coming to one part, consent and compromise decree in between parties, principles of res judicata shall not apply. Now, what does it mean? Imagine that a party was there. They were litigating in court. Later, they made a out of court settlement. They made a settlement, out of court settlement. Okay, and what happened is the court did not decide anything. Parties themselves only decided something. The compromise merely sets the seat for the court, as the principle of res judicata does not apply to a compromise or a decree made by that person. But where the court on the facts proved comes to a conclusion that the party intended that the consent decree should have the effect of finally being this, the res judicata may apply. So what they are saying, a consent or a compromise decree is not a decision by the court. Court has not decided. You all both only have made an out of court settlement first. It's acceptance of something to which the parties has agreed. Parties had only agreed and they had signed the consent papers. The court did not decide anything. The compromise decree merely has set a seat on agreement of the parties. So court has said, okay, fine, it is, the parties have agreed to it. Now, whether the doctrine of res judicata applies, can it be said that on compromise the party was actually punished? So they say, listen, normally that punishment is not by court, right? So if the party said, imagine I had to pay you 30,000, I could not pay. I said, please adjust for 25,000. So we made a consent letter and I said, I'll give you 25,000 as a compromise between you and me. So here nowhere court was involved. So it cannot be said that the court has punished me. Okay. So here they are saying that the doctrine of res judicata is about when the court has punished. Here you all have made a compromise, it does not apply. However, if in the settlement terms it has clearly been mentioned that listen, here the party will not file another case, it will be deemed that it is a decision of the court and court has a power, then we will say listen, res judicata applies, because court will say that you have clearly said that this is like a punishment and you are agreeing to it. So then the terms of the court, they will see that if the parties intended that the the particular consent order should have the effect of a proper judgment, then the res judicata may apply. Because sometimes what happens, I'll tell you how it works. If consent order was made, it was outside with the party, so we'll say res judicata does not apply. But now what happens? So I had also done one consent orders for my client. So similarly, what we had done is there was a dispute was settled between the parties. They came to court, and in the front of the court they had given their consent, they had submitted it. So they are showing the court that listen, we want to end it and end the matter. Then the res judicata will apply. So if you inform the court, if you satisfy the court that yes, we wanted it to have an end to the litigation, then the res judicata may apply. Now coming to another important thing which the court can, in the exam they ask, is what do you mean by set off, counterclaim and equitable set off? Now what do they ask? They ask what is the difference between set off, counterclaim and equitable set off. So a separate exam question comes, what do you mean by set off? So set off means reciprocal acquittal of claims. My claim is set off against your claim and only the order for the balance has been passed. Set off, right? Your demand and my demand gets set off. After the set off, whatever is there, the final judgment will be given. For example, if I am claiming 1 lakh from you and you are claiming 25,000 from me, I am claiming 1 lakh, you are claiming 25,000. So then the court will say if all this is correct, then we will say listen, only an order of 75,000 should be done, whereas 25% which is set off. So how do you name it? It is reciprocal acquittal of claim. I have to claim, you have to claim. So that much amount we'll set off. In little technical language, they call it as it has the effect of the plaintiff's claim is set off against the defendant's claim. Finish. Counterclaim means what? Counterclaim is when I am claiming 1 lakh. You go on to say that in addition of set off, I am claiming 3 lakhs from you. So this is amounting to a separate demand only from me. So it's not only being set off, I have started countering. So who will make a counter? The defendant. So the defendant can file a counter claim where I say okay this and I will put 10 more allegations on them. So this amounts to claiming from that guy only now. Let's understand. In set off what happens? I was claiming 1 lakh from you. You said that I had to pay you 25,000. So then I say, okay, let's set it off. You have to pay me 75,000. This is a case of set off, where that small amount got set off and then you have to pay me. Now, second example of counterclaim. I am claiming 1 lakh from you, but you are claiming 2 lakhs from me. So this is instead the defendant is now claiming. So this becomes like a counterclaim. So counterclaim is when the defendant makes a counterclaim. It is like a reverse claim where the party is now liable to pay to this guy, to the defendant. That is called as a counterclaim. Equitable set off. So equitable set off is a kind of set off where the amount rupees is not certain. Okay, it is not yet to be, it is not yet exact amount is not there. It will be decided by the court. For example, in set off we had seen 25,000 was set off. In equitable set off, it is an uncertain sum of money that I am claiming. For example, I say that listen, you have to pay me 1 lakh rupees. But as set off, what you are telling that this guy has caused me damage. I don't know exact amount of damage, that has to be quantified by the court. So equitable set off is a kind of set off where you are claiming uncertain sum of money. So then your court will have to appoint a particular valuer or particular more thing to figure out what is the amount. For example, if you had caused loss of reputation, now how much loss of reputation has to be found out? Or if you had damaged some of my car, so how much damage to the car is there, it has to be ascertained. So when I claim an uncertain sum of money as set off, it is called as equitable set off. This will have to be ascertained. later. Clear? So in India, here is there uncertain sum of, in India, distinction between legal and equitable set off is recognized, and your English courts do not recognize equitable set off. Now we come to injunction. So what do you mean by the term injunction? Let's understand. Now injunction, temporary injunction. Okay, now pay attention. Temporary injunction means to ask one of the parties to do or not to do something till the final decision is given. So injunction is to do or not to do something till final disposal of case, till final disposal of case. Clear? Yes. Now let's take an example. I tell the court that this guy, till the final it has been decided who the two brothers are fighting. One is saying I am the owner of the house. The other one is saying he's the owner of the house. Now court will tell that listen, till the final case, the party cannot sell the house. So this is a temporary injunction. We can give an injunction that till the final order, do not sell the house, do not damage the house, do not do this, do not dispossess anybody, don't remove anybody, don't damage the property, don't do anything which will defraud the creditors. Okay, don't do anything which will cause an irreparable harm to the particular other party. So court can order some of these things to ensure the interest of the party is maintained. So this is called as a temporary injunction. Why it is temporary? Because court still has to hear the entire case. After hearing all the temporary injunction is passed on basis of prima facie evidence. Once the entire evidence has been got, etc., then a final injunction will be done, which is called as perpetual injunction, which happens at the end of the case. Temporary injunction is during the case, or mostly in the initial part of the case. Now, once a case is filed, for example, if there is loss to me, I filed a case in court that listen, this has happened. So then they will say, okay, fine, what is the problem? I say, like, this party had done this wrong to me. So I go to court, I file a petition. So let's see how it works. So we go to court. So there is a plaintiff, and then there is in civil matters we call it as a defendant. Okay. Now plaintiff goes to court and tells the court that listen, this defendant has done this, that, etc. to me. So court will then call the defendant. It's called an issue of summons. Okay. So court issues the summons to the defendant, telling him to appear in court and answer that why the plaintiff is right or wrong. So this summons, how it will be issued. So first of all, summons is a proper letter. If you know, someone from the court will come with a summons letter telling that what date he has to come to court. You have to sign the summons and then appear on the date with all the documents to prove your case, and then the fight begins. Okay. So let's see, delivery of summons. So how will the summons be delivered? By the officer of the court. The court will tell who is the officer who is going to take the summons. Now summons, where it will be delivered? It will be delivered to the residence of the defendant. Second is it could be given through registered post, etc. Okay. Now what happens, a very common thing happens is the defendant normally does not want to come to court, so they hide. They do not take the summons only. They say the door is locked, they don't open the door only. So that summons, they say we didn't receive the summons only, because they don't go to take. So then what the court does, one summons they will issue. Second time also they will set the officer. Third time the court will believe that this guy is not ready to take the summons. So they will issue something called as a substituted summons. A substituted summons is they will stick the summon copy on the door. Properly they will stick on the door, and it is deemed that the summons has been given. So where the court has reasons to believe that the defendant is trying to avoid receiving the summons, then the court will affix the summons on a conspicuous part of the house, and it is deemed that it is he has received the summons. In case of companies, they will give it at the registered office. Now imagine, for some reason the person did not go to court to defend the matter. Then what will happen? Plaintiff filed a case, defendant didn't go to court. He said, I don't care, who cares, I will not go to the court. So now if you don't go to the court, then the court has a power to pass an ex-parte order. Ex-parte order is an order passed in the presence of one party only. On listening to one party only, court will pass the order. So that's like a heart attack that the defendant will get, that they didn't, because I did not go to court, the court has a power to pass the order only as they want. Yes, you're the party, whoever is there, and they'll pass an order. If for any reason I realize that an order has been passed, I did not know, I was a genuine case, I did not know. So what is my remedy? Now in the exam they had asked that if an ex parte order has been passed against your client, what remedies does that person have? You tell me. If an ex parte order has been passed against a person, what remedies does the client have? So he can go in appeal. He can ask the same court to review it. He can tell review. He can apply for setting aside the ex parte order, or he can tell the court that the order has been received by fraud. So 4 powers he has. One is he can file an appeal. He can apply for review. That is the same court only he tells to review. He can apply for setting aside of the decree, or third, he can prove that it was by fraud. 4 things are there. Affidavit. Now what do you mean by affidavit? Now a statement on oath. So we write normally any petition is being filed, any document is being given, in below only we write that all the matters stated above are true to the best of my knowledge, and best of my knowledge, and you sign it. So affidavit is a statement which has been taken on as a promise. It is in writing and signed in first person. First person means what? When it is written, I, son of so and so, residing at so and so, solemnly affirm as a below, promise as below, that I am whatever it is there, and you will sign. Now another important thing which the exam they ask is reference review revision. What do they ask is reference review revision. Sir, what does it mean? It means, first of all, 3 things. Reference review revision. Section is section 113, 14, 15, right? Section 113. Okay, let's write and finish it off. So reference is under section 113. Review is under section 114. And revision is under section 115. Sir, what does it mean? So reference is when we go, just a sec. Okay. Give me 2 minutes. So till then you read what do you mean by reference review revision. It's a repeatedly asked exam question. So I'll tell you, you read it and tell me whether you understand. So reference is when we refer the matter to a higher court, when a lower court has a confusion, like how you are a junior, if you have any difficulty you ask your senior. So a reference is when you refer the matter to a higher court. So lower court is taking a point of law and going to the high court, to the higher court, and saying to the high court, please, they go to the higher court and they say that okay, so it should come, just give me 2 minutes. Sir, join the notes link. Okay. Till then, please like the video, and share it with your friends also. Okay, chalo, my this is done, should come now for you all also. Yeah, I'll explain misjoinder also, don't worry. Very simple. Harshvardhan, don't worry. Chalo, first, okay. So what we were doing till now, we are doing something called as reference review revision. Okay. So what do you mean by the term reference? So reference is when a lower court refers a point of law to the higher court. It is called as reference. So then the higher court will then pass an order as it deems fit. Now review is like in your ICSI, when you get a wrong result, you apply to same ICSI that please recheck your paper. So this is like a rechecking, it's like a review. You go to the same court and tell the court, listen, you have passed this judgment, but please go through it again because of MOD. The court will say, why should I review my own judgment? So they will say, review the judgment because of MOD. It was a mistake apparent on face of record. It was a mistake which is very apparent, obvious mistake has been done. Second, there was a discovery of a new fact which was not known at the time of passing the judgment. And third, any other reason which the court deems fit. So in such cases, the court will review its own judgment. This is given 114. Now 115 is about whether lower court has passed a wrong decision. Then the higher court will call for the records of the lower court. A higher court, high court, will tell the lower court, come here. What stupid judgment you have passed? The lower court will say, I'm sorry. I said, you did not have jurisdiction. You have exceeded your jurisdiction. So then that is a case of revision. Revision is when the high court calls for the record of a subordinate court. When we feel that the subordinate court has exceeded its powers, has failed to exercise its powers, or has done acted in exercise in a jurisdiction illegally, you've acted illegally or materially irregularity has been done. So then the high court will then call and settle the matter. This is very similar to certiorari in Constitution of India, where the lower court is called into court by the high court and then the judgment is checked. Now, can a minor file a case, or can we file a case against a minor? Sir, with respect to minor, who is a minor first? So a minor is a person who is below, who has not completed 18 years. But when it comes to House of Wards, okay, where it is under the House of Ward for children who have been mentally challenged, for them the age of majority is 21. So 18 in normal cases for children who are under Court of Wards, for them the age of majority is 21 years. So yes, a minor can and be sued. A minor can sue with the help of a guardian and be sued, but only his property can be sued if some gain has been taken from that property, etc. for the minor. Okay. Personally, he cannot be made liable. Now, mostly it is minor. What happens when the minor attains majority? Now, when the minor has attained majority, become 18 years, then he can decide whether guardian should continue the case in his name, or whether he should continue the case in his own name, or whether he wants to drop the case. So all the three options has been given: either continue in own name, continue in guardian's name, or end the matter. So minor gets three options. Clear? Then we see summary procedure. Summary procedure are for very, very small cases, which is their court wants to quickly end it. So summary suit or summary procedure is a speedy settlement of dispute. Court wants to summarily end it. Now when we summarily end it, we will only end matters where we feel that it is with respect to bill of exchange or something which is very clear-cut one-sided case. So in summary suits, you do not give a right to defend beyond 10 days to the defendant. So for example, if it's a case of bill of exchange has been bounced, okay, they have told in case of bill of exchange, hundis, promissory note, someone has given a promissory note, etc., and that has been bounced. So then for all those matters can be summarily tried. In that they say that leave to defend, that it's a summary case, so we cannot prolong for a long time, so we give the defendant only 10 days time to come and defend himself. If he doesn't appear in 10 days, then we can pass a ex-parte order. Okay, so such leave, even 10 days will not be given if we come to know that the defendant doesn't have any substantial defense, okay, or the claim has been admitted by the defendant has admitted it, or we feel that he doesn't have any defense only, so we'll end it. The summary suit must be brought within 1 year. So moment the cause of action has arose, within 1 year you have to go to court, then we can summarily end it, and summarily end is a speedy settlement of dispute of bill of exchange, hundis, promissory note, etc. Here they do not give much time, only 10 days time for the defendant to defend, to come in court. The object is to prevent unreasonable obstruction by the defendant. So we do not allow too much of delay in the cases for summary cases. Now comes place of suing. Now place of suing means what? Where should we file the case? So place of suing means where case should be filed. Where the case should be filed. So ideally, if you know the rule, how does it work? Wherever the property is situated, in that whoever has the closest, the court having the jurisdiction over that property, there you will file the case. Let's see each and every one. First, let's say if there is a hierarchy given, that first this court, then this court, then this court. So according to section 15, it says that you should always file the case first of the lowest grade. So court with the lowest grade should be you should first appear there, or you will directly go to Supreme Court. So they say no, normally you go to lower court, from there is appeal, then from there is appeal, and then in the end you go to Supreme Court. So always a suit will first be tried in the lowest grade. Now section 16. Now what are they saying? If it is respect to property, it is with respect to certain immovable property, then where will you file? Now let's see. The following suits related to property shall be instituted in the court within whose local limits the property is situated. Common sense, yes or no? So where court in whose jurisdiction the property is situated, we will file a case. So what kind of property disputes can be there? With respect to partition of the property, two brothers are saying I want to split the bungalow. Recovery of immovable property, the property is in possession of someone else, I want to recover it. Foreclosure, a bank has not got the money, so then they will ask for foreclosing or mortgage. Okay, foreclose means to close the mortgage by selling the property. Okay, any rights of anyone with respect to the immovable property, for compensation for wrong done to a immovable property, recovery of movable property for all of the above mentioned. So with respect to movable property means money. So rent coming out is movable property arising out of immovable property. So answer, all these are the types of disputes, but all of it where you will file the case? You will file a case in the court where the immovable property lies or is situated. How simple is this? Very simple. Now, for suits for relief or compensation for wrong of cause to immovable property held by the defendant, the suit may be instituted in whose jurisdiction the property is situated or whether defendant resides. Now see, option has been given that when you're filing a case against the defendant for something wrong done to the property. So we are telling the plaintiff will file a case, he will ideally file where the property is situated, or he's getting an option, you can even file a case where the defendant resides, because obviously this is in favor of the defendant. If the defendant is residing here and here only I file the case, so it's very good easy for the defendant to go and file a case. So option has been given to the plaintiff. If normally property case is always filed where the property is situated, but if the plaintiff wants, he can even file where the defendant resides for the case, for the benefit of the defendant. Now we saw of one classic case we'll see of section number 17. That what if, now this was very simple question, that property in whose jurisdiction it is situated. Now what if a property is situated in a place where two courts are having jurisdiction? So let's say the jurisdiction of court A and jurisdiction of court B is coming, of court A and court B. Now how can the jurisdiction be so big? Now sometimes, let's say if it is a huge piece of land, it is a huge acres and acres of land. Now what is happening is, it is coming in this jurisdiction also, this land is coming in this jurisdiction also, this jurisdiction also. So which court will take up, court A or court B, or any court? So the answer is any court can take up the matter. Any court can take up matter. And court will also take up a matter where the property is situated, plus the full value of the property can be decided. For example, let's say they plan to go to court A. So the court A will decide the full value of the property, okay? I mean, even which is going in this jurisdiction. So the value will be full, because option has been given, because what they have written in section 16, let's read it, you will come to know. Now it is a suit for immovable property within jurisdiction of different courts. So where a suit is obtained for relief within the jurisdiction of different courts, the suit may be instituted in the jurisdiction where any of the portion of the property is situated. So any of the portion. So even little bit portion is there, then that court can take up the matter. And interesting thing is, the value will also be of full value. It won't be just only my half I will take, his half it will be there. Any court can take up the full value. Now section 18 talks about place of institution of suit where the local limits of the jurisdiction are uncertain. If imagine there is for any reason uncertainty, for what we couldn't apply the rules, we couldn't find out only where it will lie, then any court can take up the matter and they will put a proper note that listen, there is a very big uncertainty and that is why we have to close the matter. So we are taking up the matter. So where there is uncertainty, then any of the courts can take up the proceed with the case, but they will have, and it will be have the same effect as if it was within its local jurisdiction. So whenever there is a doubt, courts can mutually agree that you take up the matter or you take up the matter. Then they can take up the matter and then it will be deemed that it will have the same effect that is as if it was actually in their jurisdiction. Okay, however, this will be treated invalid if we came to know that there was no uncertainty only, or there was a miscarriage of justice. Then we'll say you're doing fraud with us or what. So then they can disallow. Now section 19, suit for compensation for wrongs to person or movable property. Now person means what? Let's say a case of defamation. If I'm doing a wrong to you means what? I have defamed your reputation. So then where you can file a case? So you can file a case where the defendant resides. If imagine someone has issued some public, some defamatory content. So you will file a case where the defendant resides, you will file a case there. Okay, and so if wrong was done in the local limits of one, so if let's say I had given a particular interview, and in the interview of a live broadcast was being done and it was in Mumbai, and defendant who is there is in Chennai, so then you get an option either where the cause of action arose or where the defendant resides. So two options are there. Always this is the same thing, where it will be either in the jurisdiction of court where defendant resides or where cause of action arose. Okay, so this is like a constant thing only. Now, one point I have to teach you, which is called as misjoinder of case. Misjoinder. Okay. Now, what does a misjoinder mean? Now, misjoinder could be of two cases. One is a misjoinder of parties, or it could be a misjoinder of the misjoinder of case or a subject matter. A subject matter. Now, what happens? Let's say there was a dispute. There was a dispute between tenant versus tenant. Now, in that case, one tenant, what did he do? He added the landlord also in the case. So then the landlord will say, listen, it's a misjoinder of the case. What do you mean misjoinder of the parties mean what? If a party has been wrongfully added, if any party is wrongfully added in case, he can remove his name by filing a misjoinder of party. That listen, you have wrongly joined me. I have nothing to do with this case. Second, misjoinder of the subject matter. For example, there was a family dispute, in that you have also include tax matter. That listen, this guy has not paid the tax also. Then court will say, listen, the subject matter has been wrongly joined. It's a family matter, husband, wife. Do not say that he has not paid the tax, so we don't have the jurisdiction to decide on that subject matter. So don't join wrong matters also. So joining of wrong things is called as misjoining. In the case, court will remove such joining and proceed with the case as it is there. Okay. So that is it. I have completed the entire chapter, including all amendments as well as all the past exam questions. Clear? Till here, is it clear? Yes or no? Harshvardhan, I have cleared misjoinder also. Any other thing you want to know? Any of you all want to know? Okay. Is this clear? So I have finished multiple chapters today. Okay, and I think we will take a halt here. We will stop here. Tomorrow we will do administrative law, and with that I will see if I can finish Evidence Act also. So for today I have covered multiple chapters, and all these have high weightage chapters. Okay, all of these which I've covered today are high weightage chapters, and I've covered everything. So you won't have anything coming outside the exams. Okay, so that is it. First of all, thank you all of you all for sharing the video, liking the video, and I have given a gift to all of you all in the dream batch. Go ahead and join it. It's access to all the lectures, and plus I'm also thinking out of students are studying 600-700 students are already studying from our app. That is why you don't see so many live students, because some prefer to study through the app also. They must have studied already. I'm planning to give one more additional gift surprise in the dream batch. So you have to go ahead, join the dream batch, which is either old syllabus, so join the dream batch for old syllabus, or if it is a new syllabus, you join the dream batch for the new syllabus. The link is in the description. I will be giving some gift also to all of you all. It will be in the form of a coupon or discount coupon, which you will have of approximately 500-1000, which you can use whenever you want. Okay, so that is it. Okay, that is it for today. Thank you so much, Monisha, Ravi Kumar, Bharini. Great to have all of you all. Okay, and being there for all this while makes me very, very happy. I hope I have decoded your entire JIGL subject. Also, my one marathon was already done for of JIGL. Please check that also. I have covered Constitution of India in that. So you know it's a 10-15 mark chapter with all everything there, past exam questions. So please do that. Okay. So yes, so Sona, one thing is your negotiable instrument, your sale of goods act, I think, or contract act, I will add it in the dream batch. Okay, so today mostly I will add those 3 chapters in the dream batch. So please go ahead and join it. Abhimanyu, great to have you. Rohit, great. Rohit, you had also asked me about all these 3 chapters. I will be mostly adding it in the dream batch today. And for all of you all, there will be a very beautiful gift for the Dream Batch students also. The link is in the description of the video. Priyanka, great to have you. Sona, great. Thank you so much. Hit the like button. Share the video, please. Let all your friends know about it. There's so much effort that goes in. It should reach to every single student. So many students want an English. Taking for you all, it's your responsibility to inform your friends. Okay. So I take a leave from you. Bye. Have a great day. Study hard, work hard, and exemption is guaranteed.